fires, axes high, shields strong. From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Heyo, folks! It is time again. It is time again for Texas v. McIntyre. This trial have had some development that was somewhat unexpected. I did not expect a cocaine stripper. I did not expect the victim apparently being somewhat of a creep who allegedly thus far was into minor girls. I did not expect to form an opinion regarding this case where it seems like the brains, if there is one in this case, seems to be one of, the cocaine stripper, who seems to be the one who set the victim up. But now she has testified. She might be recalled, but if the prosecution chooses to, then she more or less walks out of this free, scot-free. So I don't know what to tell you. Now, we left off yesterday because they claimed the next witness would be a lengthy one. And I was under the impression that it was another one of the snitches. I don't think so. That does not look like an alleged gangbanger. Or not gangbanger, but yeah. It seems like we are going to meet the lead detective, I believe. So that is what we have for you now. I don't know how lengthy he will be. We are currently at 32 sidebars and 13 motions for mistrial. And yeah, let's just see who this guy is and what he has to say.
All right, everyone, please be seated. State, call your next witness.
The state calls, another sergeant of Level 1.
Could you raise your right hand for me? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And do you have the microphone? Yes, if you could put that on your lapel, it's for the court reporter. All right, if you'll make sure you keep your voice up, and if you could state your name and spell your last name, please.
My name is Raul Juarez, Juarez.
All right, state, you may proceed.
Thank you, Your Honor. It's Sergeant Juarez now. Yes, sir. Well, one, who are you employed with currently?
The San Antonio Police Department,
And I guess in entirety, how long have you been employed by the San Antonio Police Department?
22 years.
And in that course of those 22 years, I guess there's promotions or a different hierarchy of where you ended up in that department. Can you describe to the jury just briefly from those 22 years of what type of experiences you've gone through?
Okay. So I started with the police department in 2003. I worked for approximately 3 years on patrol as a uniformed patrol officer on the south side overnight. From there, I went to the tactical response unit and the gang unit for, again, approximately 3 years. From patrol officer, I promoted to detective in 2010, and I was assigned to the night detectives unit, an investigative unit that works overnight. In 2015, still a detective, I transferred to the homicide unit, and I was assigned to the homicide unit until I promoted to sergeant in December of 2023.
And you stated that you're a detective in the homicide unit. How long were you a detective in the homicide unit?
I was a detective at the homicide unit for 8 years. I was a detective total 13 years.
And can you just, again, briefly describe to the jury what exactly is that, the homicide division, and what type of cases that you'll deal with?
So the homicide division is actually broken up into several parts. They investigate, everybody assumes it's just murders, but it's also in San Antonio, they also investigate traffic. There's a traffic investigation section, a misdemeanor section, an aggravated assault section. Those are things such as shootings, stabbings, those kinds of felonies. And then there's murders, murder detectives that investigate not only murders or any kind of suspicious death, manslaughters, capital murders, and in San Antonio, also officer-involved shootings.
Thank you. And let's go back into 2017. What division were you assigned at that point?
I was assigned to the murders section at homicide.
And particularly April 23rd, 2017, were you assigned to the murder subsection of the homicide?
Yes, sir.
Okay. And let's talk about SAPD number 170-89350. Were you the lead detective on that case?
Yes, sir.
And were you dispatched to the scene that's associated with that SAPD number on April 23rd, 2017?
Yes, sir.
And why were you, why did you make that location?
Officers responded to the scene for a shooting. Once officers arrived at the scene, they determined that a person had died from a gunshot wound. And based on the initial details that the patrol officers called, so they hold down the scene, secure the scene, look for witnesses, but they request homicide out to the scene for the follow-up investigation.
All right, excuse me. Could I have parties approach just briefly, please?
Okay, and we start out with a sidebar. And that would be sidebar counter 33. Oh. Skipping.
Thank you, Judge. Well, so lost my train of thought there too, but let me ask you this. The location that you arrived at, was there establishment there?
Yes, there was a Chick-fil-A restaurant at 27 Northeast Loop 410.
And so is that location within Dare County, Texas?
Yes, sir.
And just to describe to the jury, what's across the highway that's sort of a landmark? Is there a mall or something across the highway?
Yeah, there's a North Star Mall is located across the highway, approximately across the highway.
So when you arrive at the scene, what are you doing? Are you delegating duties or assignments? How do you handle the scene?
Generally, when I arrive at the scene, I look for either the first responding officer or the officer that's going to handle the report, that they're going to write the report. And I try to get an idea of what the officers have ascertained up to that point as far as what has led up to this incident, and any witnesses or potential bystanders that may have seen or have knowledge of what occurred.
And speaking of, I mean, one, did you speak with the officers at the scene and get the initial, I guess, briefing on what was going on?
Yes.
And then you stated about talking to witnesses and to get their, I guess, their initial accounts. Is that correct?
Yes, sir.
And did you speak with individual witnesses at the scene?
Yes, sir.
Now, did you personally speak with all the witnesses at the scene?
No, sir.
How was that handled?
So when I got sent out to the scene, I went out with another detective, and we kind of divided the duties as far as witnesses. And since as we arrived, we determined that not only was there the incident had started from what we know just down the street from the Chick-fil-A.
And initially, when you're there, I think we had previous testimony, or rather other officers at the scene. Are they also separating witnesses?
Yes, sir.
And then are witnesses kept at the scene and released from the scene, or are they taken places?
So generally, once we determine which witnesses have seen anything, I mean, it's good that they're telling officers that they're remaining at the scene to give us information, but we need statements from those people. So those witnesses were transported to the homicide office and to provide written statements.
And I guess to be fair, are you able in every case or any case to get every witness that witnessed the incident?
No, sir.
Why is that? Through your training experience?
Generally, people don't want to get involved for a myriad of reasons. So not everybody stays at the scene. Sometimes people maybe feel they saw something but it really wasn't important. It might have caught their attention, but they didn't, link it in their mind that it was something greater. So usually that's the reason. So it's always a good thing when people do stay and cooperate.
I guess in certain, through your experience with this case or any other case or other cases for that matter, are there times that people stay at a scene and you determine that they're not an eyewitness or a witness that you feel that is useful?
Yes. So yeah, that happens.
And let me ask you also, the initial evidence collection at the scene, was there any evidence that was brought to your attention pretty quickly at the scene?
So initially, I went to where the victim was laying on the street, and there was, other than the victim, there was a shell casing right by him. But I was also informed that there had been a cell phone recovered nearby.
And subsequently, was that cell phone identified belonging to someone?
Yes, sir.
Who did it belong to?
To the victim?
And the victim in this case, Mark Saldivar?
Yes, sir.
And that's the evidence that you said was collected at the scene that day?
Yes, sir.
And later on, were the latent prints lifted from that cell phone and identified by Denise Cernel?
Yes, sir.
And did those prints come back to Jalen Bell?
Yes, sir.
While you're at the scene, were you able to see if there was any security videos or surveillance videos at that location?
Yes, sir. There were cameras at the location.
And that location is at Chick-fil-A?
Yes, sir.
And did you have the opportunity to speak with the operator of that establishment?
Yes, sir. The owner came in.
And is that I think a David Atkin?
Yes, sir.
And were you able to, I guess in some instances you're not able to see the videos right away, but were you able to view that video with the assistance of that operator, David Atkin?
Yes, sir. He opened up the establishment because I guess it's closed on Sundays, and he allowed us in there and to review the video.
And reviewing the video, because of that video, that's now in evidence, were you able to quickly identify at least a vehicle of interest?
Yes, sir.
And what the description of that vehicle? I know now you know it was a black Kia, but at the time, what were y'all viewing?
It looked like a small, dark colored, black, dark blue, small sedan.
And any indication on that video of any type of damage on that vehicle?
Yes. It appeared that it had damage, like major damage to the windshield.
And viewing that video at the scene that day, were you able to see how that damage became to be on that windshield?
Yes. So based not only on the witness statements, but on the video, it appeared the victim had stood up on the hood of the car, caused the damage to the windshield, and then fell off the car. And
speaking, falling off the car, but did it indicate at that point in your investigation, have you determined how the victim became deceased?
Yes, sir. It appeared just on initial observation that there was a single gunshot wound to the victim's side.
And was that victim, one, did he ever talk to you or that you're aware of, talk to anyone at that scene after he was shot?
No, sir. Not that I'm aware.
And so was he removed from that scene by the medical examiner's office?
Yes, sir. They removed him to the medical examiner's office.
And the going back to that cell phone from the scene, were you able to view that cell phone? Like the actual display?
Yes, I could see the display.
And were you able to gain access to any numbers that were calling that or texting that individual?
So it was an iPhone, and the notifications popped up. So I couldn't access the phone, but when notifications came up, I was able to see messages and phone numbers.
Now, I'm going to show you what's been marked state exhibit number 36. Entered into evidence. Do you recall, I know it's been a little while, but do you recall that that was the cell phone that you viewed at the scene?
Yes, sir.
And this is the cell phone that you just mentioned that you had use of notifications on.
Correct.
And those numbers that you received, were you able to make contact with individuals?
Yes, sir.
And did you ever make contact with a Lucy Saldivar?
Yes, sir.
And at some point, you spoke to Lucy Saldivar.
Yes, sir.
Now, after this initial investigation and your continuing investigation, and do you go down through a process of, in a sense, collecting other evidence? Let's say like 911 calls.
Yes, sir.
And in this particular case, did you collect and listen to any 911 calls?
Yes, sir. There were 3 911 calls.
Do you recall the individuals that gave those or made those 911 calls?
Yes, one of them was Ana Delgado, and she stayed at the scene. We got a written statement from her.
Okay.
The other one was Elizabeth, and she gave a recorded statement. The third one was a lady who did not want to identify herself.
And did those 911 calls assist you in your investigation?
Yes, sir.
And were those renditions and consistent with what you've been gathering already?
Yes, sir.
And then on April 26, 2017, were you able to identify a person of interest as Joanne Reyes?
Yes, sir.
And how were you able to determine that she's a person of interest in this case?
So I had applied for a search warrant for the victim's phone, and in reviewing his phone records, after having spoken to his mother, I knew the approximate time he left home, and I knew the approximate time where he was murdered. So I looked for the phone records at that time to see who he was communicating with, and that's how I developed that phone.
And is that how you developed Joanne Reyes was associated with the phone number?
Yes, sir.
And did you try to contact her?
I did.
And were you able to contact her at that time?
No, sir.
Did you ever contact anybody associated with Joanne Reyes?
I spoke to her parents.
And were you able to identify the vehicle, the black Kia Forte, through them?
Yes, sir.
And at that time, since you did have her number and she's associated with the case, were you able to apply for a search warrant and obtain one for her phone records?
Yes, sir.
Yeah, so this is the lead detective, I assume, and he's going to talk about the case, but it will probably be very, very focused on how they got to Mr. McIntyre, Tay-K, instead of who I believe is the actual person who set everything up, Miss Reyes.
I'll show you what's been marked state exhibit number 141.
Also known as cocaine stripper.
Can you go through that and tell me if this is familiar to you?
Yes, sir. Those are his phone records.
And whose phone records were they, or are they?
Joanne Reyes.
And these are the phone records that you applied for search warrant and obtained due to this case. Is that correct?
Yes, sir.
Thank you. Your Honor, at this time, the state would offer state exhibit number 141 of the evidence. Senator to defense for any objections? No objections.
All right, and that's state's exhibit, I'm sorry, 141?
141.
All right.
Sorry, I want to make sure that's what I'm going to say.
All right, state's exhibit number 144 is admitted.
141, Judge.
Yes, 141.
All right. Now, obtaining her phone records, was it helpful in the investigation of this murder?
Yes, sir.
When, at any time after this, were you able to actually speak with Joanna Reyes on April 27th, 2017?
Yes, sir. She called me.
And were you able at that time to set up an appointment for her to come in to be interviewed?
Yeah, she set up an appointment to come in on April 30th.
Well, let's move on to April 28th and 29th. Were you able to, on that particular day, what was significant about this particular day in association with this case?
I was off duty and I was notified that the Kia Forte that was used involved in the murder was recovered at El Potosino restaurant on San Pedro.
And is that El Potosino Mexican food restaurant on San Pedro? Approximately, how far is that away from the Chick-fil-A where the shooting occurred?
It's probably a little over a mile, roughly a mile down the road.
And you say down the road, Chick-fil-A is on the access road to 410 and Nicola, roughly. If you go to El Potosino, can you describe to the jury how you get there?
Yes, so you would turn, well, you can only turn, I guess, right out of the Chick-fil-A, heading towards San Pedro. And you would take a left on San Pedro heading into town. And El Potosino is just up to the right, one of the lights.
And this scene was processed. Was there any security videos collected from this El Potosino restaurant?
Yes, sir. I was informed that the El Potosino had security cameras.
And those are on state exhibit number 62. Were you able to view those videos?
Yes, sir.
And I guess not necessarily that day, but you were able to subsequently view those videos.
Correct.
And when you did view those videos, were those consistent with your investigation?
Yes, sir.
And after this particular day, do you also have an opportunity on April 30th? Did you gain information on a Taymor McIntyre?
Objection leading.
Overruled.
When I came into work on Sunday, April 30th, I received information naming.
Objection hearsay confrontation.
Sustained.
Well, you gained information on Taymor McIntyre.
Objection hearsay confrontation. Leading the witness sidebar.
All right. With the objection to leading, that will be sustained.
Move to instruct the jury to disregard the question.
All right, ladies and gentlemen, you are to disregard the last question.
Motion for mistrial.
Denied.
On April 30th, were you following up on information that you received?
Through,
Objection, Your Honor. That's
What's the
trying to
legal
elicit the
objection?
exact same issue.
All right, that objection will be overruled. That's a yes or no question.
Were you following up on information you received?
yes,
Thank you. And as you were proceeding through your investigation, were you, again, did you ever contact or was contacted by Joanna Reyes?
yes,
And did you ever have another conversation with her?
yes,
And I mean over the phone.
yes,
And this is April 30th, which you stated in previous testimony that she was supposed to come in on April 30th for an interview. Is that correct?
that's correct.
Did she come in for that interview?
No, she didn't.
And what did it seem like to you?
It seemed like she was avoiding me.
And at this point, did you interview anybody else in this case?
Yes, Jeremiah Rodriguez,
And where'd you interview him at?
at the homicide office.
And was anybody else with him?
His mother, Rebecca Rodriguez.
And from that interview, did you follow up with information you received in that interview?
Yes, sir.
And on May 1st, 2017, at any time did you receive any information about the possible shooter?
Objection calls for hearsay confrontation.
Overruled. That's a yes or no question.
Yes,
And were you able to, at that point, identify anybody that was listed as the possible shooter?
Objection calls for hearsay speculation.
Overruled.
yes,
Who was that?
Taymor McIntyre.
And did you develop any other information about individuals that were friends with him or acquaintances with his?
His best friend, Jalen Bell.
Your Honor, again, object to hearsay confrontation.
Overruled.
And through your investigation, did you
To my understanding, she got all three guys there. Now, this best friend thing, I don't. That is a lot of what do you call it? It's a lot of prejudicial things in that statement. Why are you calling them best friend unless you actually presented evidence where they call each other best friends, not somebody else? I'm not too fond of this.
You find out where Taymor McIntyre was from,
Dallas, Texas.
and
Your Honor, may I have a running objection to this line of inquiry?
Right, you can make your objections and the court will make a ruling.
Objection, hearsay, confrontation.
That will be overruled.
I'm going to show you what's marked State Exhibit number 115.
Yes, sir.
Are you familiar with this?
Yes, sir.
Where was this collected from?
This letter was collected from the Kia Forte when it was processed by CSI with someone.
And so this was found in the Kia Forte.
Yes, it was photographed.
This was photographed. This is the, I guess, can you describe to the jury what they're looking at?
It's an envelope with it's being mailed. The sender is from New Jersey and the receiver is Mr. McIntyre.
And it has an address for Mr. McIntyre on there. Is that correct?
That's correct.
And what's the city location?
Fort Worth, Texas.
Thank you. So leading up to this point was Taymor McIntyre a suspect in the shooting?
Yes, sir.
And you spoke with Mark Saldivar's family, is that correct?
Yes, sir.
And you got information from them, is that correct?
Yes, sir.
And on May 1st, did you have an opportunity to talk to Joanne Reyes again?
Yes, sir.
And what did you do? Did you set up another appointment with her
Yes, sir.
for a future appointment?
That's correct.
And on this particular day, did you actually get to view the video of El Patrocino Mexican food restaurant?
Yes, sir.
And was that useful to your investigation?
Yes, sir.
And was that consistent as far as your investigation so far?
Yes, it was.
And for other videos associated possibly with this case, did you make any inquiries or investigation into that?
Yes, sir. So I did check other locations from El Potosino, from the area around there. I went to Starbucks, the Guitar Center, North Star Mall, Pollo Loco, looking for other video, but there was no video that showed, which direction the suspects or the people that left the suspect vehicle at El Potosino, where they may have gone.
And after viewing the El Patrocino restaurant video that's in evidence, that's state exhibit number 62, did you indicate or rather realize that there was any other individuals of interest on that video?
Yes, sir.
Which individuals would those be that the jury has viewed that video? Which individuals would they be?
So where the Kia is parked, there's a car parked next to it, and there's two females that seem to come up to the car and interact with the occupants of the Kia, and then they leave. So I went to find out if I could identify those two females.
Through your investigation, were you able to identify those two individuals that got in that vehicle and left?
Yes, sir.
And subsequently, were you able to interview them?
Yes, sir.
And did that assist you in your investigation?
Yes, sir.
Now, what were the names of those individuals, by the way?
Jasmine and Vanessa Cruz.
Okay, thank you. Now, moving forward to May 7th, 2017, was there anything significant for your investigation that happened on that day?
Yeah, I received a call from Officer Bernal with the Dallas Police Department advising me that Jalen Bell had been arrested.
Now, where had Jalen, I think you mentioned just now Dallas, but where was Jalen Bell arrested?
In a
Where was he arrested, as in the city? What city was he arrested in?
Mansfield?
No.
Oh.
I'm asking you.
Oh, like Dallas, Texas?
Yes.
Oh, okay.
Bad question. That's my fault. I apologize. But he was arrested by Dallas PD in Dallas, Texas.
Yes, sir.
Thank you. Now, something significant that was found upon Jalen Bell was that 9mm handgun. Is that correct?
Yes, sir.
And subsequently, you requested this handgun from the Dallas Police Department. Is that correct?
That's correct.
And actually, numerous times did you request it?
Objection, leading. hearsay.
Sustained.
How many times did you request it?
At least 3 or 4 times over a period of months.
And then moving on to May 9th, I think I just addressed that with State Exhibit number 115 about the letters that was addressed to Taymor McIntyre and that Fort Worth address. Is that correct?
That's correct.
And again, that was found in the vehicle, the Kia Forte, the black Kia Forte.
Yes, sir.
Was also found in that black Kia Forte, was there a telephone found in that black Kia Forte?
Yes, sir.
And show you what Smart State Exhibit.
Hi, Derek.
State Exhibit number 115. Is this the phone that was found in that black Kia Forte?
Yes, that's the one that was found in the glove department.
And subsequently, were you able to identify who this phone belonged to?
Yes, sir.
Who did it belong to?
Taymor McIntyre.
Now, also looking at the photos or CSI photos from the scene at the El Patrocino restaurant on this day, were you able to view a wallet that was located near the black Kia Forte?
Yes, sir.
And I'll show you what's marked State Exhibit number 78.
Hi, Dave.
Was this that wallet?
Yes, it is, sir.
And now this wallet in State Exhibit number 78 was found near that vehicle. Were you able to ever identify whose wallet that was?
It was Mark Saldivar's wallet.
And how were you able
You
to
haven't
identify
missed
that?
anything. This is
I
the
showed
lead
his,
detective of the
confrontation.
case, and he is going to talk
Sustained.
a lot.
Now, on May 15th, 2017, did you make any requests that day?
For the gun in Dallas?
Yes.
Yeah.
And we spoke about it just previously, but I'd like you to, I'm asking you, did you request that gun that day also from Dallas Police Department?
Yes, sir.
Going on to May 16th, 2017, were you able to obtain the autopsy report for this case at that day?
Yes, sir.
And was it determined that Mr. Mark Salvador was shot by a handgun, or rather a firearm,
Yes, sir.
and was deceased because of that?
Yes, sir.
At that particular day, did you speak with anybody else related to Joanne Reyes
On which day, sir?
on May 16th? Or May 16th through the 28th?
To Joanna Reyes, I spoke to her mother.
And then on May 30th, did you try to gain access to Mark Salvador's cell phone?
I had been trying to do that.
And so I guess what the difference is sort of like you can make access to the actual physical phone, but then you can also request the records. Is that correct?
Object to leading.
I'll retain on it. How do you, I mean, one, what type of records can you obtain from a cell phone?
So I had obtained his cell phone records, so I could tell incoming calls, outgoing calls, things of that nature. But because I could not access his phone, I could not,
They already had phone expert on. Why are they talking about it again?
access anything else from the phone itself, as far as like apps or call logs, contacts, things of that nature.
And then this is the individual, Mark Salvador, that you testified earlier to, that you got phone records.
That's correct.
And that's different from the actual cell phone.
Yes.
Also, at the scene of El Patrocino restaurant, an SD card was found. Were you able to view that or analyze it yourself?
So it was found. I tried to, it was damaged, but I still tried to put it into multiple SD card readers. It didn't work. I eventually ended up sending it to our tech unit. Maybe they have a way of getting information, but they were unable to retrieve any information from that SD card.
And moved on to May 31st. Did you ever speak to a Jameson Medina?
Yes, sir.
Did you gain information from that individual?
Yes, sir.
Did that assist you in your investigation?
Yes, sir.
And during this time, did you also speak with Jeremiah?
Yes, sir.
And again, gain information from this individual.
Yes, sir.
And Did you speak to Olivia Reyes, mother of Joanne Reyes again?
Yes, sir.
Now, on June 20th, 2017, did you ever receive any type of gunshot residue results?
Yes, sir.
And who were the gunshot residue results?
For,
Go ahead.
for Mark Saldivar.
And after the accumulation of your investigation to this point, you've spoken to many individuals, is that correct?
That's correct.
And you've viewed the Chick-fil-A video,
Yes, sir.
you've viewed Del Papasino Mexican food restaurant video,
Yes, sir.
and done your own investigation into this case.
Yes, sir.
And so on June 26, 2017, what did you do on that particular day?
I submitted for a SID request for Taymor, McIntyre, and Jalen Bell.
And if you can you describe what a SID request and what it is a SID?
So it's a number. It's a unique identifier. People have it for different reasons, but generally it's if there's going to be a case filed against a person, there needs to be a SID associated with that person.
And you said you requested it. Did you receive a unique number that is associated with each of these individuals?
Yes, sir.
Can you please tell us what the unique SID number for Taymor McIntyre is?
108-5716.
And I believe you stated that you also received one for Jalen Bell. Can you please tell Julie what that SID number is?
108-5713.
Now, at this particular moment on this date, have you interviewed Joanna Reyes yet?
No, sir.
You had spoken to her,
Yes, sir.
but not fully interviewed her.
That's correct.
Then on speaking of the next day, June 27th, 2017, were you able to speak again with the parents of Joanna Reyes?
Yes, sir.
And what did you inform them about?
Objection, hearsay, confrontation.
Overrule.
You can answer the question, sir.
I told him that I felt that Jonah was avoiding me, and that she was likely going to be charged with capital murder.
And that's something you informed them of on June 27th, 2017.
Yes, sir.
Let's go to the next day, June 28th, 2017. Did you make a request that day?
Yes, I requested again to have the gun that was found on Jalen Bell transferred here.
Do you know if it was transferred that day or not?
I do not.
Now on June 30th, 2017, what was significant about this day?
Through my investigation, I found out that Taymor McIntyre had been arrested in New Jersey.
And Your Honor, may we approach?
Yes.
Okay. And that brings us up to sidebar counter 34. So 34 sidebars and 14 motions for mistrial. Don't know what to tell you.
All right, ladies and gentlemen, there's a matter that I need to take up outside your presence.
Oh.
So it's probably going to take 5 or 10 minutes. So I can have you all wait for us 5 or 10 minutes, or either I can send you on your lunch break now, and then I would have you all back here by 1:30. So do you all want your lunch break now? All right, I see some head shakes. All right, please be seated, everyone. Let me give you your instructions that I've been giving you at each break, and hopefully at some point in time, you're going to memorize it before I even say it. So make sure your badges are always visible, because sometimes people will talk about different cases, but if they see your badge, they'll know.
Yeah. Let's see. Okay, let's see what this fuss was all about.
All right.
Please make it interesting.
Your Honor,
So,
may I just make a brief request?
yes.
When we're doing that instruction to the jury, would the court consider advising them if someone does try and speak with them, if they were to advise the court or the court personnel?
Yes.
Thank you.
You're welcome. All right. So, State, you mentioned that you were going to ask questions about an extradition from Tarrant County.
Well, no, actually from New Jersey to Tarrant County, Judge.
All right. So what is the purpose of asking about his extradition to Tarrant County?
Well, the purpose of Your Honor is to direct rebuttal to defense's opening, and also to some of the cross that they have questioned some of the officers or rather witnesses on. in particular to the 7-year gap, or 7.5 to 8 year gap that was mentioned numerous times in defense's opening and mentioned numerous times throughout this trial. And I believe that's leaving a false impression that the state, at least Bexar County, was not expediting this actual case. And so it's rebuttal to that to say that he was extradited to Tarrant County. Well, I mean, ideally, to stand charges for capital murder, I can understand how that might be prejudicial, Your Honor. And so we're not asking to get into the fact of what the charge was, but that he was facing charges in Tarrant County for that purpose. And that this
Oh,
officer,
just for a moment, because they're opening the door.
close the door.
All right.
This detective has knowledge that this individual, Taymor McIntyre, was up in Tarrant County for several years, awaiting to resolve those charges. And hence then he was extradited to San Antonio or Bexar County, Texas. So that does not leave a false impression that the state of Texas and Bexar County DA's office was not expediting this case, because when he was actually brought here, actually for a capital murder, he was brought to trial rather quickly compared to other capital murders that start from start to finish in Bexar County, Texas, Your Honor. So that's the purpose. It's rebutting the contention that defense put in front of the jury that the state had lagged on this one.
Yeah, Mr. McIntyre is already convicted of one murder. That was years ago. Years ago. So now they are claiming, oh, we extradited him. What was it? 4 years ago, I think. Yeah. Do you think? Honestly, first of all, it is prejudicial for the prosecution to tell the jury that he had something in another county, which they will draw the conclusion that he was convicted of something. They can't. Now have the defense open the door for it by saying they have dragged their feet. Maybe. But even if it's 7 years or 4 years, I don't really care. It's still an unnecessary long time for all of this.
For over 7 to 7.5 to 8 years.
All right. And your response?
Well, Your Honor, while we have talked about the length of time as it related to the firearm and that issue, I do not believe that we have ever suggested that the length of time that it has taken to prosecute Mr. McIntyre is part and parcel of why we've criticized the investigation. And if Mr. Graham could be a bit more specific as to what exactly it would rebut. We are not suggesting, nor do we plan to argue in closing, that this 7-year gap should be held against the state, other than just simply there was a piece of evidence that was sitting in the evidence room for 7 years, which might have had scientific bearing. But I don't think that issue is in play either, because there's been nothing either, I think, in discovery or in any of the testimony that has stated that the reason the gun lingered in evidence was because of the Tarrant County prosecution. In fact, it sounds like the gun has been in police custody here in San Antonio until sometime later in the year of 2017 or early 2018. So I don't think that the issue about his extradition directly to Tarrant County rebuts anything that we've said.
All right. And Attorney Goldstein?
I'm going to do something probably that's going to make everybody.
No, it will not.
Well,
Well, it won't make
perhaps
me
not,
mad
but
because I don't get mad, but go ahead.
I think we would stipulate that other than the fact that the gun was not processed, even though it was in their possession, we asked for continuances. I don't think we intend to argue and have not argued, have not questioned, and we would stipulate that they should not hold the length of time that has taken to bring us to trial against the state in any way, Your Honor. I would reserve the issue of that wouldn't stop them from evaluating a piece of evidence that might have been critical to some of the officers.
All right. Well, this is going to be the court's ruling. With the caveat, if you all want to make a stipulation, you can make a stipulation. But without a stipulation from both sides, this is going to be the court's ruling. Number one, state you're not allowed to mention that he was awaiting charges for a murder case in another county. I would think it would be appropriate for the witness to be allowed to stipulate that the defendant was extradited to Tarrant County. And then when was he extradited to Bexar County?
I don't have that in front of me, Judge. I can get that.
So I think that would be fair is, I'm sorry, when?
I believe 2019,
All right.
but I don't, we're not asking and we don't mind the stipulating.
So it was 6 years ago. He was extradited to Bexar County. I mean, in my opinion, this is just a prosecution trying to get bad acts or bad character evidence in against Mr. McIntyre.
That none of that should be held against us then.
Well, if you all want to stipulate, and again, it's completely up to you. If you want to stipulate that the defendant was extradited to Tarrant County, then extradited to Bexar County
Okay,
in
we agree.
2019 or whatever year it is, I'll allow the witness to testify to that, or either you all can do a stipulation to it. But sir, you're not allowed to, I'm sorry, Sergeant, you're not allowed to say what the reason he was extradited to Tarrant County.
Yes, ma'am.
All right. So whatever charges that were pending in Tarrant County are not to be a part of this trial unless for some reason a door is open to that to be discussed. Does everyone understand?
I do, Your Honor. I just have a question.
Yes.
So, sorry. The other question is that he was extradited to Tarrant County, stopped there, or that he was extradited to Tarrant County for charges that pending? Or
No,
just Tarrant
no,
County?
just that he was extradited to Tarrant County.
Okay,
And if this witness has information to say he was extradited to Tarrant County in whatever year that was,
okay.
and then he was extradited from Tarrant County to Bexar County to whatever year that was,
Okay.
but no mention of the charges.
Your Honor, my only question about that is, I don't know what purpose we have in even mentioning an extradition to Tarrant County. The phrase, he was extradited to Tarrant County, means there was a judicial demand for him for a criminal matter,
The jurors don't know I don't know if the jurors know what an extradition is.
but they may. The phrase has one meaning, and someone may understand that. I mean, I don't understand because we're not using anything about the time it took to get Mr. McIntyre to court here in San Antonio against the state. It seems like this line of inquiry is unnecessary at all.
Couldn't we agree that he was brought in custody to Tarrant County and thereafter brought to Bexar County in 2019?
Well, one, I don't think he was brought in 2019 because it's 2025, and I think that he was brought here in, what's that?
I think.
Because when it-
Says, yeah, with
Prosecution, you brought this to the judge without actually knowing when that happened.
August 9th, 2019.
Okay, okay. Oh,
So that's juvenile.
I'm sorry.
As long as they show that he was in custody.
I apologize here. You're correct, because I didn't realize he was a juvenile. I'm going by when I had to guess.
And that also, I mean, like.
Well, here's the thing, time out. If y'all want to stipulate to something, you can stipulate to something, but I've made my ruling. Now, the other question is, to the members in the gallery, I usually don't allow children in the gallery because of the nature of our cases. And sometimes children, depending on their ages, they can't sit still or they want to be somewhere else. And then just as a side note, the courtroom is filled with germs. There's germs on the carpet, germs everywhere. So there was a child that was in the courtroom, I don't know, approximately 4 or 5. Defense, did you have any objections to the child not being or asked to leave the courtroom?
No, Your
Not
Honor.
any objection.
And they might learn bad habits from the council table.
Okay. So if anyone has, we can go off the record. So if anyone has any questions about the court rules and bringing children in, you can just let the deputies know. Yes.
I have a question about his nieces and nephews and sisters, and I just wanted to know, can they see him? I mean,
You
I
that
know they can't talk to him.
Yeah. No, well, I will tell you with regards to that, anyone seeing him,
Yes, ma'am.
you'll have to do it with the deputies. Deputies are in charge of security. I'm a firm believer that everybody stays in their lane, so I don't try to do security. So if that's the reason, you'll need to talk to the deputies about that. And whatever they say about security, that's what they say. All right. All right. Is there anything else?
Not from the state.
All right. So we're going to be back at 1:30. Rule has been invoked. You know what that means. You can't talk to anybody about this case.
Yes, ma'am.
All right.
All right. And now we are going to after lunch. I was a bit further behind than I expected. Dun 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 dun. And let's go.
The jury comes back.
Yes.
I would like to briefly confer with Mr. Garahan about a proposed stipulation
Okay.
as it relates to what we talked
Sure.
about. I haven't seen it myself.
I had Lexi is printing out one-liners.
Oh, what?
One-liners. She would be one of those license. She would call for them. Would take it from Jersey to Tarrant County on a certain day. Certain days.
Okay.
Which is how they do it.
Yeah.
So
That's all.
this was after lunch yesterday, and they are talking about the stipulation because
Show it to me.
Either way.
defense really don't want
Just don't think
this
about it.
witness to talk about
About that, he can't- it was just-
Mr. McIntyre being charged with another
Yeah,
crime
that's essentially
in
what
another
Yeah,
county.
I mean, so do you, I mean, y'all want me to approach my-
All right,
my
let's
witness?
skip ahead. Jury's coming in.
Juarez,
All right, State, you may continue.
Yes, Your Honor, thank you. Sergeant Warren, I believe you were speaking about, Taymor McIntyre being apprehended in New Jersey. And after he was apprehended in New Jersey, was he then transferred to Tarrant County?
yes,
And then was he transferred here to Bear County?
yes,
Thank you. Now, that was on, after the lunch hour, that was on June 30th, that, again, that Taymor was apprehended in New Jersey, is that correct?
yes, sir.
Then let's fast forward to August 22nd, 2017. What is significant about that date?
Joanne Reyes was arrested.
And was she, where you recall where she was arrested at?
Hector County, Texas.
And then was she subsequently transferred back to Bear County?
Yes, sir.
And when she was transferred back here, did you, or were you ever contacted to, that she wanted to speak to you?
Yes, sir.
And did you set up a interview with Joanna Reyes at that point?
Yes, sir.
And did you go to the actual jail or facility to interview her?
Yes, sir.
And were you given that opportunity
So she wanted to snitch. No surprise there.
to interview her at that time?
Yes, sir.
And did you speak to her about the case that we are here in court today for?
Yes, sir.
And did you show her any photographs?
Yes, sir.
Like 128, change it to 128, 130, 131. There's a reflector there.
Yes, sir.
Now, these photos have already been entered into evidence. Are these the photos that you showed Joanna Reyes?
Yes, sir.
And did she identify each individual in these photos?
Yes, sir.
And did she identify each of these individuals that are in these photos that were in the car with her that day on April 23rd, 2017?
Yes, sir.
And can you tell the jury who is named in these photos?
Taymor McIntyre is a front seat passenger. Jalen Bell and Jeremiah Rodriguez were in the back seat.
According to her. Did she tell you that she is the one who told the guys to be there? Because she wanted to get some kind of revenge on this photographer. Did she tell you that?
After discussing this case with Ms. Reyes on that day, at the conclusion of that interview, did you determine whether Joanna Reyes was a participant in this case?
I told Joanna that I believe she was a participant in the case and that she was going to be charged with capital murder.
Now, this is exactly, you had told in previous testimony today before lunch that she had spoken to her parents and told them that she was a suspect in this case.
Yes, sir.
And after the conclusion of that interview, did you reach out to a Jeremiah Rodriguez and Rebecca Rodriguez to obtain another interview?
Yes, sir, the next day.
And so on September 6, 2017, were you able to have that interview with Jeremiah Rodriguez and Rebecca Rodriguez?
Yes, sir.
And after that interview with those individuals, Was that useful for this case in your investigation?
Yes, sir.
And at the end of that interview, no, let me retract that statement, that question. Let me ask you again on September 6th, again, did you contact the Dallas Police Department?
Yes, sir.
And what did you contact them for?
They had a backlog, still trying to get that stolen gun over here in Bear County.
And that's the gun that Devin Bell was picked up with in Dallas, Texas?
Yes, sir.
And do you know at that point, was the gun transferred to Bear County on September 6th, 2017?
I don't think it was at that point, but I'm not positive when it got transferred to.
And let's just talk about that firearm in particular. Are you aware of when it did make it to Bear County?
No, I don't. I'm not aware, sir.
And in fact, do you recall when you became aware it was in Bear County?
Last 2024. Last year.
2020, so last year.
Yes, sir.
And at that particular point was, what did you request about that firearm or what to do with it?
The firearm was sent to the Bear County Crime Lab, along with the shell casing that was recovered at the crime scene at the Chick-fil-A for comparison.
And
that was the the tool mark person we listened to yesterday, who said it was not a match, I assume. So, worthless piece of evidence? Anyone?
you requested it be sent to be compared, and you got the results from that. Is that correct?
Yes, it didn't match.
Now, you interviewed all these individuals. Wait, did you ever have an opportunity to interview Taymor McIntyre?
No, sir.
Did you ever have the opportunity to interview Jalen Bell?
No.
Now, this blue cell phone that we discussed earlier, it's entered into evidence, and you had a search warrant made for that phone. Is that correct?
Yes, sir.
And did you hand that over? I guess what department would you hand that over to get that process?
So at that point, it was a crime scene unit. They had the capability to do cell bite extractions for that period.
And so is that who you would have handed it over to?
Yes, sir.
Okay. Now, speaking of search warrants, you mentioned earlier in your testimony that you got a search warrant for Mark Saldivar's phone number, and that you also got one from Joanne Reyes. Is that correct?
Yes, sir.
Can you recall this? Well, not the search warrant number, but the phone numbers that are affiliated with Mark Saldivar, and then also the one that is affiliated with Joanne Reyes.
Hi, Gigi's granddaughter. Hello. Everybody say hello to Gigi, my first and best moderator. She is currently looking after her granddaughter. And to granddaughter, I'm Uncle Nick. Hello.
For Joanna Reyes, it's 210-331-8356.
Thank you.
For Mark,
Let me just expedite it, and you can refer to your page 31 under the consent to search and search warrants.
thank you. For Mark Saldivar, it was 210-382-3826.
Thank you. And I know that we haven't marked this, but the jury is seeing you flip through some pages up there. What are you looking at?
This is my prosecution guide, pretty much my report.
So that's your, in a sense, a police report of your investigation of this case.
Yes.
Okay. Thank you. Now, did you ever investigate anything about Taymor McIntyre's Twitter account?
Yes.
And do you recall what, I guess, the handle or the name of that Twitter account was?
Tay-K 47 USA.
And how was that useful for your investigation?
In identifying and getting a date of birth for Mr. McIntyre.
Yeah, apparently Mr. McIntyre decided while he was on the run for this or the other murder, he decided to put out music on social media and got a lot of views. Views that probably afforded him his his team of lawyers. So yeah, this will also be a trial where we check out the defendant's social media. Woohoo!
And through this portion of information on Taymor McIntyre, was that the only information that you used to identify Taymor McIntyre?
Other than lineups?
No, I'm just saying that in the totality of your investigation.
Yeah, from the witness statements that were in the car. There was evidence found in the car, such as the cell phone, the letter in the trunk of the car, the other people in the car placing him in the vehicle, which was corroborated by the independent witnesses that did not know who was in the car, but were able to corroborate statements in the video of the shooting and at the Chick-fil-A and then at El Potosino.
Thank you.
Yeah. Despite my criticism of what the prosecution is doing, the case is bad against Mr. McIntyre. It really is. Do I see a way for him to get acquitted of this? I have a hard time seeing it. I have a really hard time seeing, because there is a lot of things speaking against him. But we are still in the prosecution's case in chief. We still have the other snitches and then the defense case in chief to listen to before we make our final judgment about this case.
Now, do you recall that CSI in this case obtained what they call swabs?
Yes, sir.
And those swabs, what are swabs? What do you define them as?
They look like, they're just Q-tips. They're like wooden sticks with a Q-tip on top.
And from your knowledge and training experience, is that used to collect possible DNA or biological evidence?
They swab items to see if there's any DNA left on there, which is different. Because sometimes they do it if like there's blood or saliva or something visible. This is more where it's the surface of things, vehicles or doors, things of that nature.
Are you aware, or if you are, of like touch DNA or anything like that?
Yes.
And is that also a possible reason why they would do swabs?
Yes.
Okay. Now, in this case, there have been many swabs that were testified to that were done. Were those ever tested in the lab?
No, sir.
And is there a particular reason why these weren't tested?
So, I made the decision not to submit them. I felt that with the evidence that I had with Mr. McIntyre being placed in the front seat of the car and other evidence, it would have helped, but I don't think it would have hurt the case because they don't. So it's such DNA, so it doesn't necessarily mean it's going to come back to anybody at all. And I felt with the other evidence I had.
So you didn't send it in because it might not have shown anything else but the people that you claim you knew was already in the car. So you didn't want. I hate this. I really, really hate this, because this, in a criminal case, one of the most important things, in my opinion, you can do is to exclude things. Because you don't want to you shouldn't want to accidentally convict the wrong people, regardless of what eyewitnesses say. Because eyewitness testimony is not reliable, especially not 8 years later. So having DNA swabs, hair swabs, at least send some of it for testing. Because for some odd reason, cocaine strippers might not be the most reliable of witnesses. Right? Right?
It wouldn't change anything.
So are you saying that
It wouldn't have changed anything? How can you say that when you're not actually testing?
let's just say hypothetically one of these swabs would have came back to a different individual, that if it was swabbed inside the car in the front passenger seat, if it would have came back to a different individual, not Taymor McIntyre, would that have changed your conclusions on this case?
No.
Would it still be that your conclusions are that Taymor McIntyre shot and killed Mark Saldivar with a deadly weapon on
Yes, there
April 23rd, 2017?
Yes, there was more evidence to support that conclusion.
Now, Ms. Sunel had been in here earlier to testify about latent prints, and she identified Jalen Bell's fingerprints or latent prints on the cell phone of Mark Saldivar, which I believe you testified to earlier, and also that Jeremiah Rodriguez latent prints were found on the exterior of the vehicle. And she also testified that she tested them against Mark Saldivar, Joanna Reyes, and Taymor McIntyre. You know, in this situation, I guess my question is that Joanna Reyes admitted to being in this vehicle, but yet none of her fingerprints were found. Is that common in cases through your experiences?
Yes, sir. Yeah. The phone is another good example. It was the victim's phone. He used it. It's his phone, and even his fingerprints weren't found on there, which is kind of like the swabs and like my decision not to submit because it's not always a guarantee that anything's going to come back to it. But the fingerprints did come back to Mr. Bell.
Thank you. And again, you know, Mark Saldivar, like you said, it was his phone, but from all intents and purposes, from your investigation, Mark Saldivar was on that hood of that vehicle, and many people testified that he was grabbing onto that vehicle, but yet none of his fingerprints were found.
Correct.
And also, there's testimony that Taymor McIntyre was in that vehicle. However, his fingerprints were not found anywhere in that vehicle also. Is that correct?
That's correct.
That is a circular argument, and it's a bad one. A circular argument is that because that happened or didn't happen, that means this also did not happen. It's a horrible, horrible argument. But nobody's objecting. I would have.
That the death of Mark Anthony Saldivar was caused by Taymor McIntyre while he was trying to commit robbery of Mark Saldivar.
Objection leading. Calls for
Same.
an issue.
What-
Instruct the jury to disregard the question.
Ladies and gentlemen, you to disregard the last question
Motion for mistrial.
tonight.
What are your conclusions after the totality of your investigation on your belief of Taymor McIntyre's actions that day?
Objection calls for opinion on the ultimate question.
Sustained.
No, you can't.
Objection.
You
You're
can't
not allowed to answer.
Were there also clothing items contained within that car that were related to Taymor McIntyre?
Yes.
And so, including evidence of the letter and the phone obtained from that vehicle, is that correct?
Yes.
Thank you, Your Honor. We'll pass the witness.
Oh,
May I
Defense.
proceed, Your Honor?
oh, that. I thought he would be a lengthy witness. Now, this cross-examination will be interesting. I mean, every cross-examination is interesting because it seems like the prosecution left out a lot in their direct examination.
Good afternoon, Detective. How are you?
Very good.
I'm sorry, it's Sergeant now, right?
It's okay.
So, fair to say, there are a lot of moving parts in an investigation like this, right?
Yes, sir.
And you rely on a lot of other people to do some of this granular, fine detail work, like fingerprint examination, extraction of cell phone data, collecting evidence at the crime scene, interviewing witnesses, et cetera, right?
Yes, sir.
You could not possibly do all of that as one person.
No, sir.
But of course, when you're delegating that many responsibilities, you're dependent on those people doing their jobs correctly, right?
Yes, sir.
And you have to trust that when they report back to you something, that their conclusions and that their opinions are something you can rely upon, right?
Correct.
There's always human error, though, in every case, right?
Yes, sir.
Okay. So I want to talk about, in terms of how this investigation developed, would it be fair to say that there's the physical evidence and then there's what people told you, right?
Yes, sir.
Okay, so let's talk about the physical evidence for a second. You know from physical evidence that Mark Saldivar is dead, right?
Correct.
And that he died from a gunshot wound.
Correct.
You know that there was a 9mm shell casing found next to his body.
Yes, sir.
You also know that there are shell casings all over the streets of San Antonio for all sorts of different reasons, right?
Yes, but there was a body next to this one.
Understood. But what I'm asking is, the examination that was done in this case never told you that that shell casing is definitively the shell casing that produced the bullet that killed Mr. Saldivar, right?
So I have video evidence and witness evidence that a shot.
And we're going to get to that in a moment.
Yes, sir.
I don't want to jump ahead. I'm just
Okay.
saying, as far as that 9mm shell casing is concerned, obviously, it's a shell casing next to the deceased person. You're investigating that man's death. I understand that. I'm just saying, there's nothing that conclusively says that 9mm shell casing produced the bullet that killed him. It just is strongly coincidental, right?
That's a little more than a coincidence, sir. Yeah.
Okay, but you know definitively it may not be the shell casing.
It's more than likely to be the shell case.
Okay,
Yes, sir.
I'll more than likely. Understood. So you found a 9mm shell casing next to this man's body in the parking lot of the Chick-fil-A, correct?
Yes, sir.
You acquired surveillance footage of this incident, right?
Yes, sir.
And that surveillance footage showed a car pulling into the Chick-fil-A, a man standing on top of the vehicle, and then someone shooting him, right?
Yes, sir.
And you knew from that generally that you're looking for a small, dark-colored four-door sedan, right?
Yes, sir.
And you put a be on the lookout for that vehicle.
Correct.
And you knew that there would be extensive damage to the front windshield of that car, right?
Yes, sir.
And you then a few days later acquire more physical evidence in the case at the parking lot of this Mexican food restaurant, right?
Yes, sir.
And so you know that you have a damaged SD card found in the parking lot, right?
Yes, sir.
And you found that subject vehicle. You found a black four-door Kia with a lot of damage to the front windshield.
Yes, sir.
And you found various items, some of which may have belonged to people in the car, some of which may not have belonged to people in the car, scattered around that parking lot, right?
Yes, sir.
Okay. You did not find a digital camera, correct?
Correct.
You didn't find any, well, you didn't find a digital camera, correct?
Correct.
You acquired surveillance footage from that Mexican food restaurant, right?
Yes, sir.
And so you see individuals getting out of that black four-door Kia on the date in question.
Yes, sir.
And so as far as your physical evidence is concerned, right, that's sort of the universe of physical evidence that you have at your disposal, correct?
Yes, sir.
I mean, you have gunshot residue on the deceased hand, correct?
Yes, sir.
You later on acquire a 9mm pistol obtained from Jalen Bell in Dallas, right?
Yes, sir.
You do comparison to that, and your analyst tells you that that's not the gun, correct?
Yes, sir.
You don't have any other weapons recovered from the vehicle or any other crime scene.
No, sir.
You do have multiple magazines,
Yes,
right?
sir. 3 magazines.
Some are 380 auto and some are 9mm.
Correct.
You don't have any fingerprints on those magazines.
No, sir.
You have a fingerprint belonging to Jalen Bell on the cell phone that you found tossed out of the car in the Chick-fil-A, right?
Yes, sir.
You have, and you spoke to, well, before I get into what you spoke to, you did an extraction of a blue iPhone in the vehicle that you found in the vehicle, right?
Yes, sir.
You believe that that phone belongs to Taymor McIntyre, correct?
Based on the data on it, yes, sir.
And you found some belongings of Mr. McIntyre's in a gym bag, right?
Yes, sir.
You found a piece of mail addressed to Mr. McIntyre.
Yes, sir.
Okay. You know that that vehicle is registered to Joanna Reyes' father, I believe.
Yes, Juan Reyes.
You have fingerprints of both Mr. Bell and Mr. Jeremiah Rodriguez that were found in the car, correct?
Yes, sir.
Okay. In terms of physical evidence, are there significant things that I'm leaving out of that recitation?
No, sir.
Okay. So if we just look at the physical evidence of the case, you know that the case involves a four-door black Kia, right? The case involves a dead man, Mark Saldivar. The case involves, I'm sorry, you were going to say something.
No, yes, sir. I was in agree. So
Thank you very much. Appreciate that. You know that the case involves a 9mm shell casing, correct?
yes, sir.
I did forget one thing. When the car was searched, a live 380 auto round was found in the front passenger seat of the car, correct?
That's correct.
You found a condom in the car as well, correct?
Yes, sir. Under the front passenger seat.
So you know that someone was shot, and you know generally where they were shot, and you know that they were on top of the car when they were shot, right?
Yes, sir.
Okay. The physical evidence doesn't tell you who shot, correct?
No, sir.
The physical evidence doesn't tell you who was in the front seat and who was in the back seat, right? let me back up
Yeah.
because I think I know why you're thinking.
Clever.
You obviously do have the footage from El Potosino that shows people getting out of the car, right?
Correct.
Okay. But you can't look at those images on the footage and say, oh, that's Taymor McIntyre, that's Jalen Bell. Like you just without any other information you've learned in the case, right?
Well, yeah, without any information that I do have.
Without people telling you, that's me, that's them, you wouldn't be able to say from looking at that footage who's who.
So yes, the footage isn't clear enough, but I do have that information.
And we'll get to that in a moment. I'm just trying to take stock of what you've acquired physically.
Yes.
Okay. You don't know whether that black four-door Kia went directly to that Mexican food restaurant after it left the Chick-fil-A parking lot, right?
That's what I was told, that it went directly there. So that's what I.
Okay.
I go back.
I'm just asking, does the physical evidence tell you whether the Chick-fil-A parking lot, whether that car went from the Chick-fil-A parking lot directly to El Potosino Mexican restaurant? So the physical evidence could be consistent with that, and it could be consistent with them making a pit stop someplace or stopping some other location, right?
Yes.
They could have had a Chinese fire drill and everybody changed their seats. The physical evidence wouldn't tell you one way or the other.
No, sir.
Okay. The physical evidence doesn't tell you which gun was used to shoot Mark Saldivar, right?
No, sir.
The physical evidence doesn't tell you what was stolen from Mr. Saldivar, correct?
So the physical evidence includes the video. A backpack was taken, and Mr. Bell was seen stealing a backpack.
Okay. So you see Mr. Bell in the video putting on a backpack,
Yes,
right?
sir.
But let me ask you this. There's no footage of Mr. Saldivar getting in the car with the backpack,
That's
correct?
correct.
And so in terms of just what the physical evidence shows us, you see a man putting on a backpack.
Yes, sir.
That does not tell you that the backpack was stolen, right?
By itself, no, sir.
Okay. So suffice it to say, despite the fact that there's a lot of physical evidence collected in this case, there's still a lot of unanswered questions from just the physical evidence, right?
Yes, sir.
It was necessary for you to talk to people who might have firsthand knowledge of things in order to better develop your investigation, correct?
Yes, sir.
And some of those people that you spoke to were innocent bystanders around the Chick-fil-A on that day, right?
Correct.
And they gave you accounts that were consistent about some things, right?
Yes, sir.
Like, for example, they saw that there was something going on unusual in that car before it pulled into the Chick-fil-A parking lot, right?
Yes, sir.
Some people said that they were playing around. Some people said they were fighting. You know there are differing accounts about that.
Yes, sir.
Some people describe the people in the car as all Hispanic. Some people describe the people in the car as being African-American, right?
Yes, sir.
Some people said the African-American in the front seat had an afro with a blonde streak in it. Some people said he had short cropped hair.
Yes, sir.
So a lot of people got a general idea of what happened, but I mean, in your training and experience, is that pretty par for the course for innocent bystanders watching something like this happen?
Yeah, people on a Sunday afternoon minding their own business and something like that happens, they have different perspectives of it.
I like this cop. He is answering as honestly as he can. He doesn't try to hide anything. I like this cop.
So it gives you like
Impressions.
a rough sketch of what happened, but not like the kind of detail you need as a detective to really drill it home.
Yes, sir.
Okay. And then, so if we take the physical evidence plus the innocent bystanders, there's still a lot of things that you don't know.
Yes,
From that information, correct? Like we still don't know why they were playing around or fighting in the car.
correct.
We still don't know who was in which relative seat in the car.
Yes, sir.
We still don't know who shot the gun.
Yes, sir.
We still don't know which gun it was.
Okay, by name, you're right. Yes, sir.
Okay. We still don't know which gun it was.
Yes, sir.
Accounts also differ about how the gun is used from those innocent bystanders. You'd agree, right?
How, sir?
Well, you recall some of the witnesses told investigators that the gun was pointing up,
Yes, sir.
and some investigators said the gun was pointed at
Yes,
the
sir.
deceased. And some people said that the gun was being used as a bludgeon instrument.
Yes, sir.
And some people said that the gun was in a different hand and that the blows were coming with just a closed fist.
Yes, sir.
So we still don't know exactly how the fight unfolded in the car, right?
No, sir. Just everybody's perspective of what they saw.
Right. And there's no real way for you to weigh one or the other, right?
No, I just put all of their input into the investigation.
Understood. The accounts differ as to how many shots were fired, right?
Yes, sir.
I think we have some people that say 1, some people that say 2, some people that say 3.
Yes, sir.
Okay. So you've got a general idea of what's going on. and you have some physical evidence that does give you a sense of who was in the car. But you'd agree with me that without someone talking to you about what happened inside of that car, you wouldn't be able to file a capital murder charge on anybody, right?
Well, yeah, because I don't have names.
Well, sure, you don't have names for one, right? Sometimes when people die in a gunshot-related incident, it's murder, right?
Yes, sir.
Sometimes when people die in a gunshot-related incident, it's self-defense.
Yes.
Defense of property could be a reason someone takes another life with a gun, right? So those things are things. Defending a third person could be a reason to take another life with a gun, right?
Yes, sir.
Those are all things that without input from people who were there, you don't have enough information to rule those things out, right?
Correct.
Okay. So that leads us to Joanna Reyes and Jeremiah Rodriguez, right?
Yes, sir.
These are people that you were able to interview, correct? And from their interviews, you learned that they're the ones that tell you that Mr. McIntyre was the one who produced a pistol, right?
Yes, where he was seated and that he produced the pistol. Yes, sir.
Okay, so they give you the seating arrangement in the car, and they give you that he's the one who brandished a firearm, correct?
Correct.
They're the ones that tell you that he's the one who shot Mr. Saldivar, correct?
Correct.
They're the ones that tell you that he's the one who started the fight, correct?
Correct.
They're the ones who explain why Mark Saldivar was in the car, right?
Yes, sir.
They're the ones that explain, I mean, they just give you their opinion. It wasn't self-defense, right? They helped you rule that out.
I mean, I asked them the question and they answered that they didn't believe it was self-defense.
Okay, so when you go into an investigation, it's important not to have a preconceived idea about who's responsible and what happened, right?
Yes, sir.
That's the way we make mistakes, is by having the idea of what happened so buried in our head that we ignore other things that might tell us something else, correct?
Yes, sir.
Okay. So going into this, based upon the physical evidence, you understand that any one of those four people in the car could potentially have been the shooter.
It was the front seat passenger.
Okay, well, I mean, what I'm getting at is the physical evidence we just talked about doesn't tell you who was the front seat passenger, right? We agree on that much.
Yeah. Yes, but I don't look at, you're breaking it down and I didn't look at it just broken down.
Okay, well, when you're not looking at it just broken down, the missing piece of your puzzle comes from Joanna Reyes and Jeremiah Rodriguez, right?
Yes, sir.
Their information is the only information that you get in this investigation that tells you about the goings-on inside the car, correct?
That's not the way the investigation goes, because I combined all the elements that you explained to come to the conclusion that Mr. McIntyre.
Yeah, but that's not what the defense is asking here. The only thing that puts Mr. McIntyre in the front seat, passenger front seat, doing the deed, are two other people in that car.
Shot and killed Mr. Saldivar.
Okay, well, I mean, if I mix flour and water together, I'm never going to get a porterhouse steak, am I?
Your Honor, I object to argument.
Sustained.
If the evidence by itself doesn't tell you a specific fact, then I guess what you're suggesting is that what they've told you is corroborative, and that's why you can add the physical evidence back into this and reach the conclusion?
So the physical evidence is still a part of it. It's still part of the case. I have the independent witnesses that, yes, they did have differing views and perspectives, but generally, gave a summary of the events that they saw. They don't know who's in the car. They don't know what's happening, but they also don't have any reason not to be truthful.
Okay, but we acknowledge that those individual people, while they give similar accounts, have big differences, right? The race of the people in the car is a significant difference.
Yes.
Do you agree?
Yeah, yes, they do.
The number of shots fired is a significant difference, right?
Yes, sir, but that's normal.
Well, and of course it's normal. I mean, I get that. What I'm asking is, let's say that hypothetically, you're investigating someone who posts videos of them giving a talk on some subject matter in their living room, and you're investigating them for a crime. And someone comes forward and says they committed a crime, and I know that because this man in his house has a marble mantelpiece and a cuckoo clock and green walls and everything else. And you look at that, and everything that person told you is something they could have gotten from watching his videos online, right? Would that be corroborative of what they're accusing him of?
No. Are you saying like, would that suffice?
Right.
No.
Okay. Because everything they're telling you is something that they could have known independently, right?
Yes.
Okay. So in this situation, Joanna Reyes and Jeremiah Rodriguez told you that the decision to rob was made by Taymor McIntyre in the moment, right?
Yes.
And they denied having anything to do with it, correct?
Yes, sir.
They were totally surprised that this had occurred.
Correct.
And then they talk about things that they saw and observed in the car, right?
Yes, sir.
But many of those things either are just things that are in the car, or they're things that you can't know one way or the other. You have to take their word for it. Is that a fair
Correct.
way to describe it?
No.
Okay. So as an homicide detective, fair to say almost none of the people that you ever think about as potential suspects in a murder case want to put themselves closer to the crime that you're investigating, right?
Correct.
Like unless they're coming in and say, I confess I did it, right?
Yes.
Some people do just confess.
Yes.
But unless they're going to confess, people are typically trying to minimize their involvement in the offense, correct?
Yes.
And as a detective, you're trained to pick up on the fact that suspects frequently minimize their involvement, right?
Yes, sir.
And there are lots of ways to minimize involvement, correct?
Yes, sir.
One of which is to point the blame at someone else, right?
Yes.
One of which is to give you what they think you want to hear, right?
People do that. Yes, sir.
They're trying to figure that out. It's a cat and mouse game with them, right?
Yes.
And you're supposed to be watching out for those things.
Yes, sir.
And you're also trying to assess whether or not what this person's telling you can be independently corroborated, right?
Correct.
Because that's the key in case someone has lied to you so badly that they're not credible, right?
Sure.
You have to think not just in terms of what you're going to ultimately decide, you have to think about how this will be presented and explained to 12 people one day.
Yes, sir.
And so keeping those things in mind, if somebody lies to you for a significant portion of your interrogation of them, that's going to send off some red flags for you, right?
Yes, but people generally don't start by telling me the truth.
Okay, fair. But people generally either come clean.
I suspect we are going to hear a lot about this in the defense case in chief, because while they were snitching, the other people in the car, they made claims that we haven't heard in this trial because it's not credible. But that's the problem when your star witness is a cocaine stripper and another person who might be the actual shooter.
Shortly thereafter, or you're going to write off what the rest of they say is also potentially false, right?
Unless I can support it somehow with other evidence.
Okay, fair enough. So Jeremiah Rodriguez lied to you for a significant portion of your interrogation of him on both occasions. Wouldn't you agree?
More on the first one. Yes.
Definitely more on the first
Yes.
one. Like for what, almost half the interview.
Yes,
He told you he wasn't in the car that day.
correct.
He said he was watching Redbox videos with his siblings at home, right?
Yes, sir.
He indicated he didn't even see these people that day.
Yes, sir.
And he persisted in that for a very long time.
Correct.
And then even after he gave up that he actually was in the car, for the rest of the interview, he told you there was another person in the car.
Correct.
I think his name was John, right?
That's correct.
And he just, that John was sitting in somebody's lap, right?
Correct.
Okay. Jeremiah Rodriguez, you mentioned earlier that you requested the generation of SID or SID numbers for Jalen Bell and Taymor McIntyre, right?
Yes, sir.
Meaning you intended to charge them with capital murder.
Correct.
And when I say charge, I mean you're going to present this information to the DA's office. You're going to apply for an arrest warrant. You know, that process.
Yes, sir.
You did not do that for Jeremiah Rodriguez,
Yes, sir.
despite the fact that he lied to you for at least an hour in total,
I didn't feel there was enough for capital murder
based upon what he told you.
on Jeremiah. Yes, sir.
Okay. Joanna told you that Jeremiah had a gun, right?
Yes, sir.
That Jeremiah was a drug dealer.
Yes, sir.
That Jeremiah had photography equipment, right?
That he had photography equipment?
You don't recall that?
No, sir.
Okay. Would it surprise you if that was something that was discussed in there? or
No, I mean, I believe you.
Okay. Joanna Reyes was avoiding talking to you for months before finally you got to speak with her, right?
That's correct.
And you only got to speak with her because she was arrested out of county.
That's correct.
And she was arrested in Odessa, right?
Yes, sir.
A long way from home.
Yes, sir.
And she also was trying emphatically to suggest that she didn't know anything about this, that it just happened, right?
Yes.
She told you for a lengthy period of time that she wasn't even in communication with Mark Saldivar, right?
Yes, sir. They had communicated. It had been like over a year or something like that.
And that Taymor McIntyre was using her phone to communicate with him.
Yes, sir.
She eventually admitted that wasn't true, right?
Yes, sir.
So she was similarly trying to minimize her involvement.
Yes, sir.
Okay. And
This is a good
So-
cross-examination.
you didn't ask Joanna Reyes for her phone in that interview, did you?
No, I didn't.
And Joanna Reyes in that interview never told you that someone else broke that phone.
No, sir.
Okay. Yeah, it's good practice to try and get the phones of people involved in homicide or this, at least witnesses this close to the action in
Yes,
homicide, right? For all sorts of reasons, correct?
Correct.
And in particular, in this case, what people knew and what was said to them is important, correct?
Yes, sir.
So, I mean, if things are as Joanna portrays it, then, well, I'll withdraw that question. One moment. You were asked some questions and there was an objection, so I don't want to go into the substance of it either. But you were asked some questions at one point about information that you received from someone other than Jeremiah and Joanna. I'm just going to ask it. Did you receive a Crime Stoppers tip in this case?
Yes, sir.
And fair to say, you later learned that Crime Stoppers tip was from someone who is one of Jeremiah's friends, right?
Yes, sir.
So I gather the thought crossed your mind that Jeremiah was trying to feed law enforcement information through the Crime Stoppers tip.
I didn't think that. No, sir.
Okay. It didn't strike you as unusual that a Crime Stoppers tip came in that eventually would be traced back to someone very close to Jeremiah Rodriguez?
It was an anonymous tip. It's a Crime Stopper tip, so I have to work and develop them. It's not trying to determine so you're trying to say if it's false, but
Let me ask you this.
because I could corroborate details of the Crime Stoppers tip. So things that mentioned in the Crime Stoppers tip, I already knew.
Okay, well, let me back up. If somebody wants to try and sell you on a particular version of the story, and they encourage other people to go in and corroborate their version of the story through an anonymous tip, then that isn't really corroboration, right?
So again, sir, I didn't just go with that. I had other evidence, physical evidence, the witness statements, which still supported what the Crime Stoppers said. And I did still talk to people and mention in the Crime Stoppers tip.
Okay,
Eventually.
but when we talk about the witness statements, we're talking about Joanna Reyes and we're talking about Jeremiah Rodriguez, right?
I meant the independent witnesses also.
Who we've discussed at length, accounts differ as to what they say, right?
It's what they saw, sir.
Each of them, what they saw, right?
Yes, sir.
Okay. You don't, because it's an anonymous tip, there's no way for you to understand if the tipper has a motive when you're receiving the information. Fair to say?
At that point, no, sir.
Right. But in this case, you did later learn that there might be a motive for that Crime Stoppers tip.
I didn't believe there was a motive as you're presenting. No, sir.
Okay. Similarly, like you didn't believe that you needed to walk a warrant for Jeremiah Rodriguez for capital murder.
Correct.
Okay. Even though you know that some of the accounts indicate that Jeremiah Rodriguez attacked or hit Mark Saldivar.
Yes.
Okay. And there's at least some account among all these different versions we've discussed where Jeremiah Rodriguez may have been armed, right?
That's correct.
And the physical evidence indicated that there might be at least 3 firearms in that vehicle during the time period that this occurred, right?
Yes, sir.
Okay. But we didn't walk a charge on Jeremiah Rodriguez.
Correct.
Okay.
Yeah.
When Ms. Reyes was interviewed, she originally tried to lead you to believe that she was unaware that anyone had a firearm in the car when they got in that day, right?
Yes, sir.
But later on, you very casually say, what gun did Jen and Bell have? And she just says 9mm, right?
Yes, sir.
Okay. Were you able to look at Joanna Reyes's Instagram account at all?
I didn't know, sir.
Okay. So you took her word for it about how this all went down and what was being arranged.
With the physical and other witness statements, yes, sir.
Okay. What else shows what was being arranged?
Just the contact on the phone from Mark Saldivar with Joanna Reyes, sir.
Okay. You don't have the content of that communication, right?
No, sir.
You just know they spoke.
Yes, sir.
That would be consistent with her talking to Mark Saldivar, right?
Yes, sir.
We all know that she spoke to Mark Saldivar, right?
She said she did. Yes, sir.
Okay. There's nothing that leads us to believe she didn't speak to Mark Saldivar, right?
Correct.
But as to the content of it, nothing corroborates that, right?
Yes, sir.
Okay. And she's given several different accounts of what exactly they discussed.
Yes, sir.
Okay.
So what was the actual
When you are
evidence?
investigating, you were asked several questions earlier about search warrants. You recall that questioning?
Yes, sir.
And that's pretty standard because of the Fourth Amendment. You need to get warrants to search certain places that you suspect might be involved in a crime like this.
Yes, sir.
And the information you received from these cooperators was that after the shooting, everyone went back to Jeremiah Rodriguez's house, right?
Correct, sir.
Did you execute a search warrant for Jeremiah Rodriguez's house?
No, I did not, sir.
Okay. Did you execute a search warrant for Joanna Reyes's house?
No, I did not.
Or a search warrant for any other place that they indicated to you they might have stayed in the last 2 weeks?
No, sir.
Why why not? Why not? You have all the evidence you need to get a search warrant. Why did you avoid I liked this cop, but
You did apply for a search warrant for the phone that you determined belonged to Taymor McIntyre, right?
Yes, sir.
And when you applied for that warrant, you advised that you had reason to believe that Joanne Reyes was a person that Mark Saldivar had corresponded with, correct?
Yes, sir.
And have you reviewed that warrant recently?
No, sir.
Would it refresh your recollection to have the warrant in front of you while I ask you about it?
Yes, sir.
Okay, one moment. Let me try and find that for you. That's right. Yes. Thank you.
yeah, as Pop says, he keeps saying physical and other witness statements, but most of that
I'm gonna
doesn't
show you what's
actually
been marked
point
for
at
identification
Tay-K.
as JR1. Do you recognize that?
The only thing that actually points to Tay-K are people who have a very, very high interest in saving their own asses by pointing at him.
Yes, sir.
And is that the affidavit for search warrant for the iPhone that we've been discussing?
Yes, sir.
Okay. If you have any questions you don't recall, please feel free to refresh your recollection with that. So when you all found, and I guess let me back up. In order to get into that phone, you first applied for a search warrant to search that black Kia that was found in the parking lot of the Mexican food restaurant, right?
Yes, sir.
Okay. And then you discovered this phone through that search, correct? Okay. And in that, and so then you applied for another warrant to gain access to search the phone itself, right?
Yes, sir.
Well, I take that back. In between, you also applied for a warrant to obtain Joanna Reyes's cell phone records, correct?
Yes, sir.
Okay. So you had her cell phone records before you applied for the warrant to physically search the contents of the iPhone that was found in the car.
Yes, sir.
Okay. And the reason why you were able to get the warrant to obtain Miss Reyes's phone records was because you had taken Mark's phone that was handed to someone from SAPD at the scene at the Chick-fil-A, and you had mentioned that you were able to access his notifications that were coming up on the screen, right?
Yeah, they were just popping up on the screen.
And so you were able to call numbers
Yes.
off of that. And looking at that phone and looking at those notifications, you were able to see that he had been corresponding with a phone number that you later determined to be Joanne Reyes's, correct?
Not on the phone. Not, you're talking about through the notifications?
Yes, sir.
No, sir.
Okay. So how did you find out that number was Joanne Reyes's?
So I through the phone, through the notifications, I found that it was somebody that appeared to be family members of Mr. Saldivar. Those are the numbers I reached out to. One of them was his brother. I told him who I was. I went out to the location and I spoke to them, gave them the initial information of what we thought was going on. They identified him. I couldn't give them identification for Mr. Saldivar. They gave me his number. I applied for a search warrant for his phone records. Once I got his phone records, I looked at the approximate time that Mr. Saldivar was seen leaving the house and when the shooting occurred. And that number came up, and so in researching the number, at that point, back in 2017, you could punch numbers into Facebook, like you just find people by their phone number, and Joanna Reyes' name came up. So
Okay,
through that process.
understood. So, but let me back up. You did call numbers directly off of Mark's phone, correct?
Oh, yes, sir.
Okay, and who did you call directly off of his phone?
There were different people that I spoke to, sir.
Random people that
Yeah,
you had
yeah.
spoken to that day. Okay. And you were able to do that even though you couldn't unlock the phone.
That's correct.
Okay. And
you were calling through, was Joanna Reyes's number one of the numbers you called?
No, sir. Not that I spoke to, no, sir.
Well, did you ever call anybody that you didn't get a hold of? Did you ever try to ring Joanne Reyes's number through Mark's phone?
Through Mark's phone, it was locked, sir.
Well, I understand, but you indicated in your reporting that you had Mark's physical phone from the Chick-fil-A parking lot, right?
Correct, sir.
And as you're trying to figure out who is this man, is this phone, whose phone is this, how is it connected? You indicated that you had called numbers off of the phone.
Oh, I'm sorry. I didn't mean I called them through the phone itself. I wrote the numbers down and then called them from the office phone.
Okay, so these would be numbers you wrote down from the search warrant of Mark's phone, or the numbers you wrote down by actually looking at Mark's phone?
Just looking at Mark's phone.
Okay, but you called them from your office number.
Office or my work cell. So, but no, I didn't, other than the ones that are logged in the prosecution guide, I don't,
So you don't believe you ever called Joanne Reyes's number?
don't believe I did. No, sir.
You indicated that Joanne Reyes and Mark Saldivar had been in telephonic communication frequent telephonic communication in the hours leading up to his death, right?
I mean, they had been in communication since like midnight the night before.
Okay,
Yes.
so fair to say those would have been the most recent numbers
Yes, sir.
in Mr. Saldivar's phone,
Yes, sir.
but you didn't call them?
So no, I didn't call her number. I tried to contact her, and then that's how I ended up finding her.
Okay, you tried to contact her,
Joanna Reyes.
right? How did you find her number? Through the phone, right? But you didn't call that number.
No.
Let me kind of narrow this down. I understand, because we're talking about everything at once, and we're talking about a narrow span of time.
Okay.
I want to focus this questioning on the time period leading up to when you applied for a search warrant for that blue iPhone that was found in the car.
Okay.
Okay. So between the time that you physically acquired Mark Saldivar's phone and the time that you applied for the search warrant for that blue phone that was found in the car, let me just ask it this way. Did you ever believe that blue phone that was in the car was Joanna Reyes's phone?
I didn't know whose phone it was.
Okay. Did you suspect it was Joanna Reyes's phone?
No, I just didn't know whose phone it was.
Okay. But you had spoken to Joanna Reyes before you unlocked the phone or after?
You're talking about the blue one?
Yes, sir.
After.
Okay. Had you determined whether or not, had you acquired Joanna Reyes's call logs before you applied for the blue phone warrant?
Yes, sir.
Had you called any of the numbers on Joanna Reyes's call log?
No, sir.
Okay. In your conversations with Ms. Reyes, she frequently offered up the explanation that she was afraid as a reason why she hadn't spoken out sooner, or why she was in Ector County, all sorts of things, right?
Yes, sir.
And you tried to downplay how much danger she was in, correct?
I mean, that was just what she was saying. Yes, sir.
Right, but you were trying to explain that that wasn't as significant of a threat as she perceived it to be, right?
Well, by the time I spoke to her, Mr. McIntyre was already locked up, and that's who she seemed to be afraid of.
Okay. So that was the reason you were trying to give reassurance that there wasn't a significant risk.
I mean, I was trying to reassure her, but she sure felt like there was a significant risk.
In terms of what transpired after she gave you her whole account of things, you explained to her that she would likely be let out on bond, right?
For the warrant sheet, for the reason she was there.
Right.
Yes.
Right. That she would be at liberty after your interview. She would be able to walk out of the room. Well, I mean, sorry, that she would be able to post bond and walk out of jail, that there would be an independent reason to hold her.
Yes, I told her I was going to file at large on her for capital murder.
And at large means that you're not going to be immediately arrested just because you filed the case doesn't mean they're going to be immediately arrested, right?
Correct.
Okay.
Why the fuck not? It's her car. She is the one who has been communicating with the victim. The victim got to her car and ended up dead. How the flaming fuck does that not lead you to an actual arrest? Because she lied? Or all up until you believed what she finally said, which also might be lies. Oh God, at least he's answering the questions honestly.
Appeared to. So you said that she appeared to be afraid and concerned when she was talking to you, right?
When she was talking to me,
Yes, sir.
no, she expressed that. She's locked up. Like I think she felt pretty safe there, but she was expressing to me why she felt that way.
Okay.
Yeah.
Did you go out and attempt to corroborate any of the things that she said making her afraid?
No, sir.
Okay. You didn't go and try to conduct an investigation in Dallas where she was, right?
No, sir.
All right. You didn't talk to anybody in Dallas who she might have been living with or staying with.
No, sir.
Okay. And we already said you didn't acquire anything on her phone.
That's correct.
And you didn't even ask for her phone in the interview.
Correct.
Okay.
What?
You mentioned that you acquired DNA swabbing from the suspects, right?
Like physically from the suspect? Physically from the
Or
suspect?
you requested it
For Mr. McIntyre.
just for Mr. McIntyre?
Yes.
Did you have any DNA swabbing done on Mr. Bell?
No, sir.
Did you have any DNA swabbing done on Joanna Reyes or Jeremiah Rodriguez?
Yes.
Okay, just Mr. McIntyre.
Yes.
Okay. And you indicated that you never requested that be processed against anything on any of the items of evidence, right?
Yes.
And your explanation for that was basically you made the decision that you had enough to proceed forward without that information, right?
Through the course of the investigation, yes.
So, I mean, you do recognize that that comes with an inherent amount of risk to not check for DNA, correct?
Yes, sir. But like I mentioned, even if with the evidence that I had as physical witness and other evidence, as you mentioned, sir, I still believe that all that showed that.
And I understand what you believe. What I'm trying to get to is, I mean, for example,
Yes,
Jeremiah Rodriguez told you there was another man in the car named John, right?
that's correct.
And that he was sitting in someone's lap while they were driving around, right?
Yes, he did.
And you clearly make manifest to Jeremiah that you're not buying that,
Yes,
right? And then he starts to change his tune, correct?
Yes,
Right? And we've talked about how one of the problems with interrogating people is they're trying to tell you what they think you want to hear, right? And you have to kind of cut them off at the pass.
yes,
And so let's say that you ran that serology and you ran that DNA and it came back to a man in CODIS named John. That'd be a problem, wouldn't it?
yeah. I mean, it would definitely change things from the evidence, physical evidence, video, witness statement that I had to that point. But I didn't have that indication.
You decided that was a low probability event and that you'll take the risk and you'll file the charge and you won't charge Jeremiah.
That was not the reason I didn't charge him, but no, that's like I said, I was basing it on all the evidence. The totality.
Bottom
Yeah.
line is we just don't know what that DNA evidence would tell us.
It wasn't submitted, no, sir.
In terms of processing the automobile, there wasn't any work done to try and identify whether or not there was blood spatter in the car, for example.
That's, I mean, that's CSI's job, sir. I don't know that, I didn't get any evidence or indication from CSI that blood spatter or any other biological fluid was found in the car, no, sir.
Okay, so the thoroughness of their investigation is one of those things we talked about at the beginning where there are a lot of moving parts. You have to rely on their work. You have to trust it was competently done, right?
Yes, sir.
But if there had been blood spatter in the car, you'd want to know about it, right?
Yes, sir.
And you'd want to run serology on it, right?
But it wasn't found, sir.
Okay, and you don't know why it wasn't found. You can't say whether it wasn't found because it wasn't there or CSI didn't do
I
their
mean, that's what I
job.
choose to say. It wasn't there. Yes, sir.
As far as you're aware,
As far as I'm aware.
it
Yes,
wasn't there.
yes, sir.
I hope they did a blue light thing in the
Going back real
car.
quick to the issue of her fear and Joanna's fear, right? One of the things that you point out to Joanna in that interview that I'd like to ask you about is Taymor and Jalen Bell obviously leave town. Taymor's found in New Jersey. Mr. Bell's found in Dallas, right?
Yes,
And your understanding from talking to Ms. Reyes is that she went to Dallas and then she went to Ector County.
yes,
And maybe somewhere else we don't know.
yes.
No one was keeping tabs on Jeremiah in San Antonio, as far as you know, right?
As far as I know, no.
Okay. And you even ask her, well, if you're so worried about this, why would they just leave Jeremiah by himself?
Yes, sir.
Remember asking that?
Yes, sir.
Okay. to ask you a couple questions about that SD card that was found in the parking lot.
Yes,
You said that you tried to access it just by plugging it into a computer like you would any SD card, right?
yes, sir.
And it just wasn't working.
Correct.
So you sent it off, you said for analysis. Can you just explain for us a little bit what exactly, who'd you send it to?
So I sent it to the San Angelo Police Department has a video investigation technical unit. They're the ones that generally collect surveillance video. They help us out recovering photos, sometimes from SD cards, not just on criminal cases, on other stuff. They help CSIs out with that. So that's kind of what they do. They're detectives.
Okay, and you sent it to them and they said, we can't get it to work, we can't do anything.
Correct.
And was there any follow-up after that? Like, are there any additional steps that could have been taken to try and restore that SD card?
They're the subject matter experts, sir. They didn't indicate that there was anything else that could be done. No, sir. So I would say no.
You deferred to their experience?
Yes, sir.
Okay. So, I mean, as far as the SD card is concerned, you don't know if it's a random SD card that someone else dropped in the parking lot, or if it belonged to the deceased, or if it belonged to someone else.
That's correct.
Did they generate any kind of a report to you?
Yes, they did. I'm pretty sure they did.
Okay.
Oh, Jesus.
When do you
Christ.
think, as far as you were concerned, your interview with Ms. Reyes is in September of 2017, is that right?
Yes, sir.
And then your interview with Mr. Rodriguez is in a similar time frame, correct?
Yes, sir.
And then you file the case with the DA's office, right?
Yes, sir. Before, yes, yes, sir.
Let's talk a little bit about what your duties are as the detective on a case, the lead detective on a case, after you've taken that step of filing the charge with the DA's office.
Yes, sir.
Do you go back to sort of being eligible to catch other cases and to be reassigned to other work at that point? Or is it something where you file charges and you are frequently still heavily involved in the investigation? It's just that you've completed step one, which is I have enough to file a charge.
So the case is filed and we are still subject to receiving other cases.
Okay.
Caseload.
So you're sort of back to the normal routine, or, I mean, how many cases are you expected on a daily basis to be worrying about?
It varies, sir. Anywhere from half a dozen to more. Yeah.
Okay. So during this time period from April of 2017 until you filed the charges on it, this wasn't the only case that you were working for homicide, right?
Correct.
Okay. Around that time, do you know how many you were handling?
I would have to say probably about half a dozen. I mean, I honestly couldn't tell you right off the top of my head.
Sure. But after you sort of file charges, is that sort of a mark in your book that while you're still the duty detective for that case,
Yes.
it's not something you're going to have to deal with every day from here on out? Like, it's kind of not as far as you're concerned.
Not as much as the other cases. Yes.
Because now it's the prosecutor's job to review your prosecution guide and decide whether they like what you did and whether they think there's probable cause to get an indictment on someone and those kinds of things, right?
Yes, sir.
Okay. So, to your credit, you mentioned several times things that you want to keep following up on about this case, right? In your prosecution guide.
Yes, sir.
And one of those things that you notated is that you'd like to see ballistics work done on the pistol that was seized off of Jalen Bell, right?
Correct.
And that was something that you notated back in 2017.
That's correct.
And Mr. Garahan talked to you 3 or 4 times. You were asking Dallas to get that to you, right?
Yes, sir.
And it took a long time to get it down here.
Yes, sir. To the point that I honestly don't know exactly when it got to Bear County.
So it was not a part of your decision-making process at all when you filed the charge. You filed the charge having never looked at or considered Jalen Bell's pistol.
Oh, yes, sir.
Okay.
I mean, yes, I didn't know if it matched. Is that's what you're asking?
Right.
Yes.
You decided to file anyway, despite not having that in your possession.
Again, yes. Yes, sir.
Okay.
So the entire case rests on eyewitness testimony and snitches who wants to save their own asses. That's the entirety of the case. No blood spatter analysis, no DNA. They got some fingerprints. They got a shell casing that doesn't match the gun they found. They know that. Yeah, for fuck's sake.
Like, we're talking about delegation of duties again. You send the SD card off to those people and they come back and they say, in our expertise, there's nothing more we can do about this. You're like, okay, that's noted. Moving on to the next question. The collection of evidence itself is also not a detective's responsibility per se. That's left up to the crime scene investigators, right?
Generally, yes.
I mean, you have authority to tell a crime scene investigator, go process that, go collect that, photograph that, but it's their job to also be doing that without your direct input, right?
Yes, sir.
Okay. And there were several crime scene investigators involved in this case, right?
That's correct.
And each of them, when they get out to the scene, is notating their E1, E2, E3 for the thing that they're processing, right?
Yes, sir.
That gets confusing, can it?
Yes, it does.
And the goal is that eventually someone figures out what everything is and which scene it came from, and they give it that barcode, right?
Yes, sir.
And that's designed to kind of put the matter to an end and say, okay, this barcode belongs to this piece of evidence, and that is what it is, right?
Generally, that's the idea, yes, sir.
Okay. And in this case, the barcodes for the scene at the Chick-fil-A were generated by Kim Wong, right?
I believe so, yes, sir.
Okay. And Ms. Wong's no longer with the department, correct?
As far as I know, no, sir.
Okay. But you wouldn't have had anything to do with how they labeled their evidence or how the barcode is generated or anything else, right?
No, sir.
Now, in terms of, in this case, we have two pretty evidence-intensive crime scenes, right? We have the Chick-fil-A parking lot and we have the El Potosino parking lot, right?
Yes, sir.
And then, I mean, obviously the car is taken to a secure evidence bay where it's internally processed, right?
Correct.
But at the time that the car is discovered in the Mexican food restaurant parking lot, there's a be on the lookout for it, correct?
Yes, sir.
Who generated the be on the lookout?
I did.
Okay. When you do that, back in 2017, was there a way to link up information? I mean, like, if I'm a patrolman and I'm just going about my ordinary business as a patrolman, and I see something that matches your be on the lookout, and as a result of that, crime scene investigators are brought out to process a scene, how do they get the benefit of the notes and the field work and everything that was done at the first crime scene? How's that communicated to them?
So there's a record back then, there was a record management system. And that's kind of like the way we have now. We have a report, Mark 43, it's a report management system, which is where we put our reports. And you're able to see other people's reports.
Okay. Would it trouble you to learn that we've heard testimony in this case that some people had not seen any reports when they made the El Potosino parking lot scene?
No.
That wouldn't surprise you at all?
I mean, I don't know if they did or didn't, you know, it's the resources available.
Sure.
Yeah.
And you have to rely on what they know, what they don't know.
Yes.
Okay. When you were not the first officer that arrived at the Chick-fil-A parking lot, right?
No, sir.
When you got there, had the crime scene tape already been set up?
The crime scene was secure already. Yes, sir.
Okay. Was there ever a decision to expand the perimeter of the crime scene?
No, sir, not from my recollection.
Okay. You're aware that the eyewitness accounts sort of start this story back on the access road of the freeway, correct?
Yes, sir.
And then eventually they pull into the Chick-fil-A parking lot, and that's where Mr. Saldivar dies.
Correct, sir.
So the crime scene that was drawn did not encompass those lanes of traffic or the curbs or the grass next to the access road itself. It was just essentially looks like the property line of the Chick-fil-A establishment, right?
Yes, sir.
Okay. Did anybody go to sweep the area of the access road, like to look at the roadbed of the access road or the curb or anything like that?
The roadway, not that I'm aware of, sir.
Okay. We are aware that different witnesses have said that they think they heard 2 or 3 shots, and some said 1, right?
Yes, sir.
Okay. I'll pass the witness.
All right, does anyone need a short break? All right, so I'm going to have you all back here at 3:15. Is that enough time for everyone? All right, remember my previous instructions. Everyone please rise for the jurors.
Let's see if they are going to talk about something. Nope. Yeah, it's almost as if the cops in this case didn't want to talk to other cops. Hi, Pop. Nick, what do you think about that cross? I think it revealed a lot about the actual investigation, because it seems to solely be resting on cocaine stripper and another person in the car. That's it. Because the physical evidence doesn't put Mr. McIntyre in the car. some of the eyewitness testimony claim they saw an African American in the front passenger seat, but not all of it. It's a very weak case, evidentiary, but that has never stopped anyone from convicting. Again, in some of the questioning with other on the witness stand, the defense almost puts him in that car themselves, which might have been a mistake. It's a weak case. But yeah, it's hard to say. Folks, I'm always pro-defense. You can rely on that. Not because I believe a person is innocent, but because I want to hold the state to their responsibility to bring a good case to a jury. This is not a good case. So I'm very critical on bringing this to trial with basically just the words of snitches, which in my opinion should always be regarded as absolutely unreliable. What, do we actually have corroborating evidence? As the defense explained in their opening statement, the snitches, their testimony has to be corroborated. Has to. Because in itself, their story is not enough for a conviction. It according to Texas rules, it has to be corroborated by independent evidence. But what is that independent evidence? It's people who saw different things so far. So, can he be acquitted based on what's being brought forward? It's hard. Because I believe there is evidence in there that points him to be the active shooter. But according to law, if the jury goes so on the letter of the law that the snitches, their story has to be independently corroborated, and they can't corroborate each other because they are snitches. It has to be independent of them. So if Mr. McIntyre would have any chance here, it is a jury that goes solely by the law. But we haven't heard the entire case in chief of the prosecution. It might show up. Something might show up. Let's skip ahead.
Of the El Patrocinio, Mexico.
With the redirect.
And State, I believe it's your redirect.
Yes, Your Honor, thank you. Sergeant Warren, I believe it sort of came out on some questioning you had with Mr. Hunter, but you stated about a backpack that you saw Jalen Bell put on, and is that in the video of the El Patrocinio Mexican restaurant?
Yes, sir.
And so, again, that may not be indicative just of him putting a backpack on that it was stolen. However, was that consistent with other information you had on the case?
Yes, his Mark's brother said he left with a
Objection, hearsay, confrontation, Your Honor.
All right, with regard to hearsay, that'll be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, disregard the last statement.
Motion for mistrial.
Denied.
The testimony is already received. Was there indication that a backpack was involved in the taking, or that Mark's backpack was taken from him?
Yes.
Objection, that I think is the same. Calls for hearsay and speculation.
Overruled.
Now, again, think of it itself, putting on a backpack by itself, I guess not a crime, right?
Correct.
But no case is done in a vacuum. Is that correct?
That's correct.
And what I mean by a vacuum is I'm going to take one factor and say, hey, is this person guilty or charged or should be charged with capital murder? So, for instance, if I say Jeremy Bell should be charged with capital murder because he put that backpack on, in and of itself, it doesn't hold anything. Is that correct?
That's correct.
So that's what I mean by a vacuum. The fact is that it's a totality of everything that you did in this case that led you to believe up to that point where you filed for those warrants of capital murder against Jalen Bell and Taymor McIntyre that attributes why you believe they should be charged with capital murder. Is that correct?
Objection, leading compound question.
All right, with regards to compound question, that would be sustained.
But is any case that you work up, you just work it in a vacuum and you don't use everything that you have in a case?
No, sir. We try to combine everything with conclusions after conducting the investigation.
Now, Mr. Hunter went over at length Jeremiah Rodriguez's statements to you.
Yes, sir.
In fact, he gave at least 2 statements to you that were reported. Is that correct?
Yes, sir.
And at length, Mr. Hunter went over statements that Mr. Rodriguez told you in those statements, in that video. Is that correct?
Yes, sir.
But in the first interview with you on April 30th, at that time, had you developed a suspect of Taymor McIntyre?
Objection calls for an opinion on the ultimate question.
Overruled. You can answer the question.
On April 30th, the week after, through the investigation, I had developed the name of Taymor McIntyre.
And so when you interviewed Jeremiah Rodriguez, for all intents and purposes, as testimony was elicited from Mr. Hunter, that he minimized or was untruthful or lied to you at the beginning of that interview on April 30th, 2017. Is that correct?
Jeremiah?
Jeremiah, yes.
Yes, sir.
And at some point during that interview, as Mr. Hunter elicited from you, then Jeremiah was admitted some parts of what he was involved in of this case. Is that correct?
Your Honor, I'm going to object to hearsay and confrontation.
Yeah. Your Honor, sorry.
Oh, no, I'll hear your response.
Your Honor, response to that is that Mr. Hunter went over at length Jeremiah Rodriguez's statement. I'm trying to, one, to show that the consistency of those statements that Mr. Hunter elicited from the detective of Jeremiah Rodriguez.
I didn't offer any statement of Mr. Rodriguez's for its truth. In fact, I was trying to get the witness, and the witness did agree that those were lies. The state can't offer the self-serving hearsay just because I elicited false statements that the witness told the detective. The reason it's admissible while the defense crosses is not a reason.
Excuse me, if y'all can approach.
Yeah. All of a sudden, I understand why the prosecution chose to never call Mr. Rodriguez, which means their entire case rests on cocaine stripper. Wow. And this brings us to sidebar counter 35. And we are up to 16 motions for mistrial. Wow. Wow, wow, wow. What a shit show.
All right. Well, let me ask you this, Southern Wars. Jeremiah Rodriguez gave you a statement on April 30th, 2017. Is that correct?
Yes, sir.
And then he also gave you an additional statement on September 6th, 2017.
Yes, sir.
And combined with other evidence in this case, were the portions of this interview consistent with other corroborating evidence?
Objection bolstering.
Overruled.
Yes, sir.
And so you gained some knowledge from Jeremiah Rodriguez
Yes, sir.
from one interview at the infancy of this investigation on April 30th, just roughly 7 days after the murder of Mark Saldivar.
Yes, sir.
And then roughly September 6th, months later, you interview him again.
Yes, sir.
And between those two statements, there's consistency. Is that correct?
Yes, sir.
Objection bolstering.
Overruled.
And did you combine what you learned from Jeremiah Rodriguez and compare it to other evidence in your case?
Yes, sir.
For instance, the day before September 7th, I'm sorry, September 6th, you interviewed.
I'm not sure, because if the prosecution never actually called Mr. Rodriguez, how can they elicit information? Because this hinders the defense from impeaching by having his testimony through this witness.
Jeremiah Rodriguez, but on September 5th, you had interviewed Joanna Reyes at the jail. Is that correct?
That's correct.
Objection leading.
Sustained.
Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, you're to disregard the question.
Motion for mistrial.
Denied.
Did you interview anybody on September 5th, 2017?
Yes,
Who was that person?
Joanna Reyes
Where did you interview that person?
at the Bear County Jail.
And with the interview that you formed with her, was that on, I guess, video and audio?
It was reported on DVD. Yes.
And with her interview, the portions of that for your investigation, was that consistent with other evidence in this case?
Objection bolstering.
Overruled.
Yes, sir.
And was that also consistent with portions of Jeremiah's?
I hate the word consistent, because, for instance, this is a shot glass. It's a Bigfoot shot glass. It contains liquids. Well, not now, but it can contain liquids, which is consistent with a bucket, who also can contain liquids. Does that mean that this is a bucket? No. That is why, because the word consistent is, the word seems to many people mean more than it actually does. So this consistent with, in my opinion, it's worthless if you say consistent with, because that is, in my opinion, lower than 50-50. Much lower. Because consistent with, let's bring out this little toy. It is a Halloween ornament, a pumpkin. It's consistent with the looks of a real pumpkin carved. Does that mean I can eat the inside of this? No. But it's still consistent with. It's so misleading. Every time somebody tells you in a court of law it's consistent with, it's worthless. It's just a word that many people believe means more than it actually does.
First and second interview.
Yes, sir.
And then combined with other evidence in this case, was it consistent with the conclusions that you made about this case of Taymor and McIntyre's involvement?
Yes, sir.
And in the end, what was your conclusion?
Objection calls for opinion on the ultimate issue.
Sustained.
What did you charge Taymor McIntyre with, or what did you file? What charge did you file against Taymor McIntyre at the conclusion of your investigation?
He was charged with the capital murder of Mark Saldivar.
Everything in this redirect is a circular argument. This because this because this, and it all circles around. But the entirety of it goes back to this cocaine stripper. Sorry, I hear I get a phone call. I need to answer that. Let's keep going here.
Unfortunate. Mark Saldivar's phone. Were you able, I think there was confusion earlier. I want to clear that up. Were you able to access the actual phone?
No, sir.
So actually have the passcode or access code to enter it and look at the call logs?
Yes, so I'm sure by now most people know that it's an iPhone, it's a notification. So the way he had this phone set up whenever he got a call or text, certain, however you can select the notifications on the phone, those things pop up on their own. They're the settings that were set. So when I looked at the phone, not being able to access it, make a call, anything, I was able to see those notifications, and that's where I gleaned that information.
And then other information, as you testified to previously, that you received from the call records, that is not part of the actual phone.
That's correct.
Pass the witness, Your Honor.
Briefly, Your Honor. So you're aware that Cellbrite can crack into locked phones, correct?
Yes, sir.
It's a routine practice of law enforcement to break into locked phones, right?
Yes, sir.
And that was not done in this case.
That's correct.
You were asked about the consistency of these individuals' stories as it relates to your recommendation that these men be indicted for capital murder, right?
Yes, sir.
Obviously, as a detective, you have to understand and know the Texas Penal Code, correct?
Yes, sir.
And in this case, the contention is that the reason it's a capital murder is because it was done in the course of a robbery. That's what you recommended, right?
Yes, sir.
And you're aware of the elements of robbery?
Yes, sir. Yes, making demands, taking property without the owner's consent.
You're aware that a robbery first requires a theft, right?
Yes, sir.
And theft is a separate crime under Texas law.
Yes, sir.
Okay. And then in the course of committing theft, the person intentionally, knowingly, or recklessly causes bodily injury to another person,
Yes.
right? Or they threaten intentionally to use force or lethal force.
Yes.
So when we're talking about theft, theft requires that someone have the intent to permanently deprive the owner of their property, right?
Yes.
Okay. So when you talk to both Jeremiah and Joanna, in the course of their explanation of this, they were talking about how there was a demand for a bag, right?
Objection, hearsay.
Sustained.
Yeah, I think as far as Joanna is concerned, that'd be prior sworn testimony.
Objection, hearsay, Your Honor.
Sustained.
Okay. There was was it your understanding based upon your interviews with Joanna and Jeremiah that they were consistent with each other in that they were indicating that this was a demand for a bag?
Objection, hearsay, Your Honor.
Sustained.
There's nothing about the statements that you took from Jeremiah Rodriguez on either occasion or Ms. Reyes where they indicated to you that there was prior knowledge the bag would be stolen, right?
Objection, hearsay, Your Honor.
That's been asked and answered.
Sustained.
You do not have any video surveillance footage showing a struggle over a backpack while Mr. Saldivar is still alive, right?
No, sir.
In fact, the only footage or evidence at all of the backpack that you have is the footage from the El Potosino parking lot where you see a man putting on the backpack, right?
Correct, sir.
Okay. And you never recovered a backpack, right?
Correct.
Pass the witness.
No further
State.
question.
All right. Is this witness excused or subject for recall?
Excuse by state, Your Honor.
Excused by the defense.
All right. The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this case. If you'll leave whatever exhibits with the court reporter, please.
Yes, ma'am.
State, call your next witness.
State calls Luis Lopez.
Thank you.
Thanks.
Okay, I didn't hear which one.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, have a seat. Make sure you keep your voice up so members of the jury can hear. If
Okay.
you'll state your name and spell your last name, please.
Luis Lopez, Lopez.
All right, state, you may proceed.
Mr. Lopez, how are you currently employed?
I'm employed with inmate calling solutions.
Okay, and how long have you been employed with inmate calling?
About 11 years. Yes.
Oh, jail calls.
Yes.
So before that, yeah, from what I could gather from the lead detective is it was an extremely lazy investigation. Extremely lazy. He only bothered to investigate things that came easy to him, that in some way, shape or form pointed him in a specific direction, and then he was done with it. As soon as Rodriguez and cocaine stripper told him,
Hello, Moto.
sorry, as soon as he had two people pointing the finger at a specific person, he was done. That's all he needed. And Yeah, but let's continue. Sorry, my phone is blowing up, and I have to. Sorry, folks.
And what is your title with ICS?
My official title is field tech.
Okay, and do you also act as a custodian of records for ICS?
Yes, I do.
Okay, and specifically as a custodian of records, do you maintain jail calls made from the Bear County jail?
Yes,
All right. Now, these calls, are they kept in the regular course of business?
yes, they are.
And is it a regular practice to maintain the records for the jail?
Yes, it is.
All right. And the calls that are made by inmates from the Bear County jail, are they recorded when they are released?
Yes.
And can you explain to the jury how the calls are recorded?
As soon as the inmate picks up the phone, there's a little software that allows the system to detect. And then when they start dialing, then the system starts recording at that point. As soon as they press 1 to place a call,
Okay.
the way through.
And when the inmate picks up the phone and starts the call, is there a warning that the call is recorded?
Yes, there is.
Okay. And so how does one go about obtaining a copy of the recorded jail call?
Depends on who's asking, but most of the times it's through a subpoena or a request from, the person,
A law enforcement agency?
a law enforcement agency.
Okay. And I guess, can you tell the jury what the enforcer is?
The enforcer is a system where we keep all the records for and make changes to the records for each inmate. So if somebody has an issue with the voice, we will go there and help them out with the voice through the enforcer. We also enroll them in the enforcer with their SID number and their PIN number. And then through the enforcer, that's where we listen and can get recordings from the phone calls that are made.
Now you talked about the SID number. Is that a unique identifier assigned to each inmate in the Bear County jail?
As soon as they walk in, yes.
Okay. And does the SID number have to be entered to make a call from the Bear County jail to a recipient on the outside of the jail?
Yes, SID number and a PIN number that the person or the inmate has selected themselves.
Okay. And so can you explain to the jury how an inmate would go about making a call from the Bear County jail?
Excuse me?
Did you already explain how the inmates make their calls?
How they make their calls?
Yes.
They'll pick up the phone. They'll hit 1 to place a call. After that, the system will ask them to enter in their PIN number. At that point, they enter in their SID number and their 4-digit PIN number that they have selected. Then after that, it will ask them to say United States of America for the voice recognition.
Okay. And when inmates are making calls from the Bear County jail, do they have to state their name in the call?
Yes.
Okay. Now I'm going to show you what has been marked as State's Exhibit number 118. I'm going to take it out of its envelope. But do you recognize this disc?
Yes, I do.
And have you listened to the contents contained within State's Exhibit number 118?
Yes, I have.
Okay. And are they a fair and accurate depiction of the recordings that are maintained by ICS?
Yes.
Okay. And do you know what unique identifier they were made from? The SID number they were made from?
Yes, they have the calls all have their SID number and a CSN number also that tracks.
I say this in almost every trial I cover. If you know that your calls are being recorded, do not say anything that can incriminate you. It really... Don't think you can talk in code. Everything you say can and will be used against you. That's not even legal advice.
The call.
Okay. And regarding State's Exhibit number 118, who is the inmate and his SID number that made the calls contained on a State's Exhibit number 118?
Last name McIntyre.
First name?
Taymor.
Can you say it?
Oh, Taymor.
Okay. And what is the SID number associated with that inmate?
It's 108-5731.
Okay. And you've listened to the contents of State's Exhibit number 118?
Yes.
And they're an accurate copy of the conversations?
Yes.
Okay. And they were recorded on a device that's capable of making an accurate audio recording?
Correct.
Okay. And have they been altered in any way?
No, that's all. No.
Okay. And at this time, Your Honor, the state would offer 418 to grant defense for inspection.
Your Honor, may I have McIntyre?
Yes.
Good afternoon, sir. How are you? You've reviewed the contents of States 118,
Yes, sir.
and how many calls are on this disc?
4.
There are just 4?
Yes, sir.
You know how long each of them is?
About 15 minutes each.
Okay.
Your Honor, may we approach?
Yes.
And here we go again. Bringing the tally up to 36. Sidebar counter 36. 36 sidebars and 17 motions for mistrial. Let's see here. Oh, it's a long one. Skipping, skipping, skipping. It's a really long one. I think they sent out the jury and then they brought the jury back in. Yeah, that took away 25 good minutes.
Excused by the defense.
All right, the rule has been invoked. You're allowed to discuss your testimony
Oh.
with anyone during the pendency of this case.
Okay.
So he was
Thank you very
only
much.
there for the jail calls. To-
State, call your next witness.
Yes, Your Honor. The state calls Lucy Salvador.
Lucy Salvador. All right.
To make sure.
All right, thank you.
No objection.
Maybe, if you don't mind, I'll just step out briefly and call my advocate to make sure.
All right, thank you.
That's all right. I think that the next witness, I believe, is a restroom break. I thought you had more time. Maybe, if you don't mind, I'll just step out briefly and call my advocate to make sure.
All right, thank you.
No objection.
Okay, so the witness wasn't ready.
All right.
I think that's all that's all the information I have right now, but I believe she's coming.
All right, thank you.
Ah, there she is.
All right, you can hold your hand. Cindy, are you able to clear that? The green light is not on, what I can tell you. On the microphone that she has. Okay. No, it's. Okay. All right, so you're able to hear? Can you speak? Just say. Hang on. Can you hear me?
Yes, ma'am.
All right, let me start. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes, I did. All right, you can lower your hand. Just make sure you keep your voice up so members of the jury can hear. And if you could state your name and spell your last name, please.
Lucy Saldivar, Saldiv.
Oh, Saldivar.
All right, state, you may proceed.
Thank you, Your Honor. Ms. Salvador, can you please introduce yourself to the jury?
Hello, my name is Lucia Saldivar. I'm Mark Saldivar's mom.
Okay. I'm gonna come up there. See this microphone in front of you?
Yes,
You can turn it like this, if you're gonna turn this way. Speak into that, because you're just a little soft spoken, okay?
okay.
Because everybody all the way back there needs to hear you.
Okay.
Thank you. I could barely hear you. So, one, I believe you stated that your son is Mark Anthony Saldivar. Is that correct?
Yes,
And can you tell us something about Mark Anthony Saldivar, ma'am? Like, what type of person was he?
he was my youngest son. He was a good son. He never got in trouble. He was always happy. Try to help his friends in any way he can.
Okay. And you know, I know that's a brief thing that you told us, thank you, but, you know, did he have a certain passion that he really enjoyed?
Yes, he did. He wanted to do photography.
And was that something that he did often?
Yes,
And, you know, would he want to do that for his occupation?
yes.
And I want to show you what's been marked State Exhibit number 142 and 144. Please tell me if you can identify 142 and 144.
Yes.
And what are those photos of?
My son, Mark Saldivar.
Oh, it's the mother of the victim.
These are pictures, obviously, before he.
This
was
is
murdered.
character testimony. They are trying to portray Mr.
Your Honor, I'm
Sal.
sorry. I'm going to object to the question, especially the phrasing of the question. I ask that you would
I
provide.
can rephrase.
The objection will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you're to disregard that last question.
Motion for mistrial.
Denied.
Thank you. Thank
Oh.
you.
Yes.
In state exhibit number 142, that picture of Mark, what does he have hanging around his neck?
His camera.
And this camera in this photo, was this one of his, did he have many cameras
Were
or
you-
just one camera?
He had a few, but
Mrs. Salvador, were you aware that your son was a collector of CP?
that's the one that he used the most.
And I'm sorry, that's the one he used the most?
That's the last one he got, so yeah.
From this picture let me go ahead and enter state, I'll, consider the defense name objection to state 142 and 144.
Boydar.
Yes.
Ms. Saldivar, good afternoon. The photograph that shows the camera in 142, on the last day that you saw Mark, he left on foot from your house, correct?
Yes,
And you didn't see what he left with, right?
just his backpack.
Okay. Your Honor, I would just object to 142 on the basis that it's under 403, cumulative, and there's a lack of foundation.
All right, could I see States Exhibit 142 and 144, please? And defense, you said your objection is to which one? Yes.
Sidebar counter 37. Yeah. Having her at the stand in the state's case is purely as a character witness. That, in my opinion, should open up for testimony regarding the victim's lack of character. Don't you think?
One, do you know if Mark, the day he went missing, that he never spoke to him again? Do you know for a fact if he took that camera?
I think so. I couldn't find it in his room. It was,
You could not find it in his room?
No.
Did you ever see that camera again?
No.
Your Honor, at this time, the state would approve to enter state exhibit number 142 under evidence of criminal transferring infraction.
Okay, they are
So
trying to
objections
show
and
that
speculation.
All right,
it was
objection is
a
overruled. States Exhibit
robbery.
142 is admitted.
Thank you, Judge. May I publish to the jury?
Yes.
Now, this is state exhibit number 142. Ms. Salvador, is this the camera that was mentioned during the testimony just previously?
yes, sir. Yes,
And this is the camera that Mark owned?
yes,
And this is the camera that he used for photo shoots. Is that accurate?
yes.
And then state exhibit number 144, is that another photo of Mark?
Yes.
Thank you. Now, was there anything else about Mark that, for instance, at a state exhibit number 144, that he had a passion or a collection of objects?
Yes.
What did he collect?
He collected gemstones.
Gemstones?
Yes.
And if I'm pointing at 144, looks like a necklace, was that something what you're calling a gemstone type thing?
Yes.
And was that, I guess, a very lay term, just a rock?
Yes.
Okay, thank you. Now, on April 23rd, 2017, did you see your son that day?
Yes.
And can you just describe, if you can remember, obviously that day, when you saw him and what y'all were doing throughout the day?
Well, in the morning, we were working at the yard, on the yard. We came in, he took a shower, got ready, and he told me he was going to go do the photo shoot. And I asked him if he needed a ride. He said no, that somebody was going to pick him up.
And you stated a photo shoot. Did you have any indication of what type of photo shoot?
He didn't tell me. He did tell me he was an upcoming rapper or something.
Objection, hearsay, confrontation.
All right, with regards to hearsay, that objection will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you're to disregard that last statement.
Motion for mistrial.
Denied.
Now, you stated just now also that your son stated that somebody was going to pick him up.
Yes.
And on that particular day, did you advise him of anything, before he left?
Objection calls for hearsay.
Overrule.
Did you advise him of anything before he left?
I just told him to be safe, be careful.
I'm sorry.
To be safe and be careful.
Okay. Did you give him anything?
He asked me if I had any money, and I told him I only had $10, and so I gave it to him. He leaned over and got the $10, gave me a kiss. He said,
Objection,
love you.
hearsay calls for hearsay and confrontation.
That'll be sustained.
Now, when he left, do you remember him taking anything with him?
just a backpack.
Just a
That I
backpack?
recall. The
I'm
backpack.
sorry?
Just a backpack that I recall.
And do you remember what he was wearing by any chance?
It was black gym shorts. It was a vest. I think it was gray or blue. And he had some shoes, and the socks had prints on it.
You know, this is a while back. This is 7, 8 years ago. So why do you remember that?
I just do. I remember exactly what he was wearing.
So this backpack, if you know, do you know the contents of the backpack?
No, sir. It was black. That's all I know.
But your previous testimony was he was leaving to be picked up to do the photo shoot. And did you have any contact with Mark after he left at that point? By text message or calling or
I
anything?
texted him, and he replied. And then after that, I kept texting him, and he didn't reply anymore.
And do you remember approximately what time he left?
It was
or
around. It was after 4:30, I think.
after 4:30?
Yes.
And related to Mark, were you contacted by anybody other than Mark?
The detective.
And a detective with San Antonio Police Department?
Yes.
And did they come to your house?
Yes, he did.
And did they speak to you?
Yes.
And on another day, did you also have contact with this detective?
Over the phone.
Did you ever view a photograph associated with this case of a wallet?
Yes.
I'm going to show you what state exhibit number 145. Now,
Well, my guess is since she had to identify him later on, she kind of recalls more about what he was wearing more than what he was bringing from when he left.
is this a copy of a photo and also writing that you saw back on May 10th, 2017?
Yes.
And whose wallet is in that photo?
Mark.
How do you know that this black wallet is Mark's?
Because I gave it to him. I bought it for him. I gave it to him, and I got it because of that little tassel it has.
Tassels and has. Now, is that the same photo that's state exhibit number 78?
Yes.
Your Honor, this time, well, did you write something on this photo?
Yes. This is
Objection, hearsay.
All right, the objection to hearsay will be sustained.
What I'm going to ask you is, do you recall how many, when did you give this wallet to Mark?
It had been probably about a couple of months prior.
Okay. Judge, oh no, okay. But that's state exhibit number 78 is the exact same copy of 148, is that correct?
Yes.
Okay. That is the wallet of your son, is that correct?
Yes.
Do you know where this wallet was found if you don't?
No, I don't.
Show you what's marked state exhibit number 107.
Yes.
Is this that same wallet? Ms. Seldar, I want to ask you, do you know a Joanna Reyes?
No.
Do you know a Taymor McIntyre?
No.
Or do you know a Jamin Bell?
No.
Or what about a Jeremiah Rodriguez?
No.
Just going to show you what's been marked. Just want you to look at this picture and tell me if you're able to identify the person that I showed you in this picture. State exhibit number 42.
Now, I'm going to object to this question. We filed a stipulation on this exact issue.
Objection is overruled.
And I showed you that picture. Did you recognize the individual in that picture?
Yes.
Who is that?
My son, Anthony Saldivar.
Thank you, ma'am. I'll pass the list.
Defense?
Good afternoon, Ms. Saldivar. I just have one question for you. Did Mark have any other plans or appointments or responsibilities that day, that afternoon, that might have conflicted with the photo shoot that he told you about?
No.
Thank you, ma'am. Pass the witness.
No further questions for this witness, Your Honor.
All right, is she
Yeah.
excused?
Please.
No,
Excused?
Yes, Your Honor.
All right.
yeah, unless you have something really, really damning, you never go after the mother of a victim.
The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial. All right, you may step down.
Thank you.
State, call your next witness.
Your Honor, this time state rest.
All right, thank you.
That was the entirety of the state's case, folks. That's it. All they have is cocaine stripper pointing at Mr. McIntyre. Tay-K. That's it. You have eyewitness testimony who all see different things, vaguely the same, but that's the witnesses they actually called. According to the lead detective, there were more people describing things that they chose to not call. Probably because they said completely different things. Yeah, this is it, folks. That's the entirety of the state's case. Relies solely on the words of cocaine stripper. A capital murder case relies solely on the testimony of cocaine stripper, who, according to the lead detective, lied. Who the state gave, instead of charging her for capital murder for bringing the victim to her car, she is on probation for tampering with evidence instead of risking life in prison for capital murder. This is the cocaine stripper who chose to start a relationship, an adult cocaine stripper who chose to start a relationship with a minor. That's the entirety of the state's case. Jesus Christ. Yeah, I'm at not guilty here because there's too many holes in the investigation.
All right, ladies and gentlemen.
Your Honor, may we express our condolences?
No, I mean, you all can do that after. All right. Ladies and gentlemen, the state has rested at this time. What I'm going to do is release you all for today, and we're going to come back tomorrow at 9:30. All right. Remember my previous instructions. You're not allowed to do any investigation on this case. You're not allowed to deliberate with yourself internally or with each other or talk about this case to anyone. Everything that you need to know about this case has come from inside the courtroom. Does everyone understand? All right, everyone, please rise for the jurors.
Okay, Is anything else? Yeah, I'm
You
guessing.
remain seated.
Thank you, Your Honor. At this time, Your Honor, the defense would move for a directed verdict of acquittal. We believe that pursuant to Jackson versus Virginia, the state has not proven each and every element beyond a reasonable doubt to the satisfaction of a rational trier of fact. There are many things in material disputes still at the close of the state's case that have not been resolved.
What is in dispute?
I don't believe the state has established who fired the gun. I don't believe the state has established who was in the front seat of the car. I don't believe the state has established that there was a demand for property.
All right, just one second. So your first is, you don't think the state has established who's in the car?
No, I don't believe that the state has established that he fired the gun.
All right, so you don't believe the state has established that your client fired a gun?
Yes, Your Honor.
All right, and point number two?
They haven't established that Mr. McIntyre was the individual in the front seat of the vehicle.
Okay,
They have not established that beyond a reasonable doubt. Obviously, they have.
and I'm taking, just so everyone is clear, based upon your statement to begin with, I'm taking that all of these points you're bringing up are that they have not proven it beyond a reasonable doubt. Is that correct?
Correct, Your Honor.
All right, so I have points 1, 2. What's point number 3?
So I said gun, I said seating. I don't believe that they've established the robbery element for capital murder. I do not believe that they have established beyond a reasonable doubt that issues related to self-defense, defense of third person, defense of property are not in play and not applicable. And for those reasons, Your Honor, we would ask that the court enter a directed verdict.
All right, so with regards to self-defense or defense of property, then that implies that there is an offense. There is an offense, but self-defense, for lack of a better term, justified. It's through self-defense or defense of property. Is that correct?
I believe that at this stage, Your Honor, particularly, and we will have further discussion at the charge conference, that if the
Well,
court-
if we get to charge conference, I'm keeping an open mind with your argument.
Thank you, Judge. I think at this stage, I think the court's question drives to the inquiry of confession and avoidance, but I do not believe that confession and avoidance would have to be a matter of consideration in a directed verdict because the defendants hasn't put on a case yet. And there has been sufficient evidence to raise those defensive issues. I think that the defense through cross-examination has met its burden of production of those issues. And therefore the burden has shifted to the state to disprove those defensive theories. But the problem that the state has, and a problem that they can't really, I think, avail themselves of by raising the concern of confession and avoidance, is that because they have provided insufficient evidence as to who was the shooter, what gun was used, where was Mr. McIntyre seated, all of those fundamental questions, it's hard to even get to the questions of justification.
All right, so let's start with number 1, 2, and 3. All right, state, the defense says, number 1, that there has been no proof beyond a reasonable doubt, which I know the defense is saying no proof beyond a reasonable doubt that their client fired the gun in this case.
We have testimony from a witness, one that testified that he had fired the weapon. We also have statements that were elicited by defense about Jeremiah Rodriguez stating he fired the weapon. And then we also have numerous witnesses at the scene that state that the front seat passenger is the individual that fired that weapon. We had a phone belonging to the defendant in the glove box in the front seat of that car. We also have other portions of witnesses. And on top of that, we have a video from Chick-fil-A showing that the front seat passenger particularly shot was shooting or shot the individual on that particular day. So evidence does point towards that this individual was the person, one, firing the weapon. And I guess I sort of stepped into number 2 by accident, or not by accident, probably just went into it, that he was the front seat passenger. Hence, if he was the one firing the weapon, he is also the one that was in the front seat passenger. So they sort of do go both hand in hand. And so it's the state's position that we prove beyond a reasonable doubt, at least for the trier of fact, to determine whether we prove beyond a reasonable doubt at this point.
All right, and then with number 3, the defense states that the robbery element has not been proven.
Your Honor, there's been numerous testimony also on that portion of individuals that were at that intersection that stated, I quote, "Give me my dings, give me my dings." And then several individuals said that the individual was yelling, "Help, help, help." And then also the actions of the victim as he proceeded to be kicked out of the vehicle, but then tried to proceed to get back in the vehicle, and then also proceeded to jump onto the vehicle to obtain his items. So the state's position is that it's well within the robbery limit, that also the victim himself had damage to his face, and testimony that he was being hit, not only from people in the car, but also outside the car, stating that the victim was being hit and a gun pointed towards him or being threatened with a gun. And so the state's position is that we prove well beyond a reasonable doubt for robbery.
And Your Honor, just so the state has an opportunity to respond, because I didn't say it, but they have a right to respond in the course of the motion.
in assessing sufficiency for these purposes, the court should also look to the accomplice witness rule in Texas and recognize that clearly both, as the state just stated, since all the individuals in the backseat of the car are said to have been involved in fighting with the victim, and Ms. Reyes was the getaway driver of the car, they are, as a matter of law, accomplices under Texas law. And as a result of that, the state is obligated, in order to overcome legal insufficiency, not only that a crime occurred, but they have to have corroborative evidence outside the testimony of the accomplices, which they have not done. The testimony of Detective Juarez plainly establishes that the physical evidence in this case does not point to a specific perpetrator, and that the physical evidence in this case does not mitigate against the possibilities of justification. And the only evidence that Mr. Detective Juarez seems to have in his possession that militates against an accounting of this that does not result in Mr. McIntyre's conviction is the testimony of the two accomplice witnesses, or at least the testimony of the one and the interview of the other who did not testify. So they have not established any corroboration of anything other than a crime occurred.
All right. So defense's request under points 1, points 2, and points 3 will be denied. Let's move on to your stating, I guess, defense of property.
Yes, Your Honor.
All right. So with defense of property.
Yeah, this is not unusual, folks, that directed verdicts are being denied, because for the judge to say there more or less has to be zero evidence for the jury to come to the conclusion beyond a reasonable doubt. It's not zero, folks. It's not zero.
If I'm incorrect, tell me I'm incorrect. I always keep an open mind. So I think both parties can agree that the force that was used, if it was defense of property, was deadly force.
I mean, the man was shot and killed.
All right. So y'all are parties agree that it was deadly force with property.
The state agrees that it's deadly force.
All right. So have y'all read the penal code on 9.42 about when deadly force for defense of property is considered justified? Because it states a person is justified in using deadly force against another to protect land or tangible, movable property. And I think we can all agree if the property, in this case, that's being protected is a vehicle, that's movable property. Am I correct?
Correct.
It says if he would be justified in using force against the other under section 9.41, and when and to the degree he reasonably believes the deadly force is immediately necessary, A, to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, or B, to prevent the other who is fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property. And 3, he reasonably believes that A, the land or property cannot be protected or recovered by any other means, or B, the use of the force other than deadly force to protect or recover the land or property would expose the actor or another to a substantial risk of death or serious bodily injury. So let's first address your point number 4, where you say defense of property.
Yes, Your Honor.
And I say that because I want to understand your argument, counsel.
Yes. I mean, the car is tangible personal property. It's being destroyed in the course of this incident. It is it's property of another. And so the third party concept applies with respect to the issue. First, there's gunshot residue found on the deceased's hand. The testimony received from the analyst was that it could be one of 3 things, which is that he fired a gun, that he was in close proximity to a gun, or that he handled a gun. The state has not offered any evidence that would establish which of those 3 is more likely, which I think creates the potentiality for a robbery or an armed robbery.
Wouldn't that be for a decision then for the jury decide as a trier of fact?
Well, the problem seems to be that since we've established by burden of production that he jumped onto the hood of Ms. Reyes' car and started kicking the windshield, I believe that we have shifted the burden to the state to disprove it, which they have not discharged fully, because the best they can do is that there's a 33.3% chance, assuming they're evenly weighted, which they're not, that Mr. Saldivar wasn't firing a gun. The other aspect of it, Your Honor, is that there was also testimony with respect to the backpack containing sexual paraphernalia and a concern about sexual misconduct. That questions were posited to the defendant, and Ms. Reyes acknowledged this, that there was questions related to, are you trying to rape her? Are you trying to have sex with her? What are you doing? Those were things that Ms. Reyes acknowledged were said. There was obviously significant dispute about the remainder of her testimony.
So is your argument that if somebody says anything, they can say, well, maybe somebody was talking about, maybe somebody wanted to rape somebody, maybe somebody wanted to kill somebody, then that brings in self-defense of property or self-defense of person?
I'm suggesting that because the burden shifted to them, they had a responsibility to establish more evidence to rebut it, which they have not done.
All right, state.
Your Honor, may I add? one
Yes.
point? There is ample law with respect to the damage done to the car,
Mhm.
not just to the damage to property, but that a kick, the heel of a shoe, and I'll provide the court with citations of my co-counsel.
All right, and we're not talking about a high heel. Are we talking about a high heel or a tennis shoe? What type of shoe?
Any shoe, I believe, would suffice as a deadly weapon, depending on the manner and means by which it was used. I think the law is clear on that. And I would suggest that even Sergeant Detective Juarez said that it was considerable force. And I believe the witness said in one of her interviews that he kicked at me through the window. And I believe the court will remember that testimony, recall that testimony. And I believe that that is deadly force of another. And I believe that defense can be of oneself or of another.
All right, state.
Yeah, I just don't think that this is the proper time to actually ask for this. I think that they're overreaching. I think that the whole premise that, I mean, one premise of deadly force to protect a property is to prevent the other who is fleeing immediately after committing a robbery. And that's exactly what the defendant is doing in this case. So he provoked any type of individual trying to obtain his objects from the defendant that took it from him during a robbery. So one, I think it's improper at this point for a directed verdict, because that'd be something that would be going to the trier of fact in this case and the jury charge. And there's so much overwhelming evidence of witnesses at the scene stating, and actually neutral witnesses, lay witnesses that have no association with either side, stating that the victim was the one being robbed. And that's the state's position on it.
I don't think that that's a fair characterization of the innocent bystander's testimony, for one. And for two, again, Mr. Graham is speaking confidently that Mr. Saldivar was the man robbed, and so that it really should be the other way around. But the only testimony in this case that has established that is the testimony of the accomplice, who is not the witness to be able to establish the corroborative detail necessary to establish that. So I think that as much as he can say that that's the state's position, the state has not discharged its burden to prove that beyond a reasonable doubt.
Well, what I can say is I think counsel has the definition for corroboration incorrect. But what I will say is the request and motion for directed to verdict is denied on all counts. And we'll be back here tomorrow at 9:30. Cindy, we can go off the record. So at 9:30, state if you have, yes.
Let me make one other request.
All right, we're back on the record.
Yes, sir.
Cindy, we're back on the record. Yes.
Thanks. I would just like to say for consideration tomorrow that I believe the state has put Mark Saldivar's, the victim's character in issue. They had his lovely mama, who I apologize, but I worry when we don't give somebody a little religious preference, but I think by asking the question that were asked, specifically, and the response is he was a good boy, he never got in trouble, puts his character, the purpose of that was to put his character in issue. And I think that opens the door to the fact that the officers found, without using it in order to poison the jury's mind, but I think that opens the door to evidence of child pornography on his phone.
All right. I haven't seen any evidence of that.
Well, excuse me for a moment.
Yes.
What was it?
On,
There,
I don't want what somebody said. Is there evidence on the complainant's phone?
absolutely not, Your Honor, and I was incorrect. I misspoke.
All right. So,
However, I believe there will be a witness, and I believe we are convinced that the court has ordered us not to go into it. But since the question was asked yesterday, I was confused. as to
Well,
the context. What I believe they have put his character in evidence, and if a witness has such evidence, I believe we're entitled to put that on.
well,
Your
the question becomes what evidence? If it's just somebody saying something,
I believe
then-
they're entitled to say they saw it or that he said it. Or,
no. What I can tell you all, number one, so I think it's been established by the defense that you do not have any evidence that there was any child pornography on
the phone.
the victim's phone. And I say
Absolutely,
victim,
and I
but
apologize.
the deceased person's phone.
Yes.
So all
We are not making that argument, Your Honor.
And
We never
I made
have.
it, and I was
That's what
wrong.
Mr. Goldstein said.
All right. And then if you have a witness who's, I guess, going to come in and want to say something they saw, then the court will take that up outside the presence of the jury to see if it should, if it meets any
If it's
objections
a mess,
of the rules of evidence or not.
and we will approach outside the presence of the jury before we ask that question.
Yes, because that's in the motion in limine.
And the court has advised us accordingly.
All right. So we can go off the record. So if you all will be here, we're going to start at 9:30. If there is some witness who's planning to come in to testify about character, then I would suggest that that person be, I'm always nice saying, I would suggest they need to be here at 9. So if anybody wants to take them on board here outside the presence of the jury, that can be done.
Your Honor, I don't think we are there yet, but I can assure the court that we're not going to delay anything. But if we have such a witness, when we're able, I don't think we have a witness here right now, but assuming we are able to acquire such witness, the minute we have that, we will advise able counsel for the state. We'll call it to the court's attention and the court can deal with it as they wish. I don't think we got anybody to be here at 9.
Okay.
So we can sleep a little late.
All right. Thank you. And so I want everyone to instate, I'm sorry.
Yeah, okay. Since this is starting to come to a close of the case, because I don't know how many witnesses the defense has. So let's go to this morning and simply continue.
There, somebody said, oh, we're going to have pork chop on a stick. And I'm like, how do you put a pork chop on a stick? And let me just tell you, you can put a pork chop on a stick.
Put anything on the stick and fry it.
Okay, let me just tell you. This is what I discovered.
And now I'm hungry. Now I am hungry. Is that a thing? Pork chop on a stick? It has a bone. Why do you need a stick? So that brings us to actually day 8. And we are at defense case in chief. We are at 37 sidebars and 19 motions of mistrial. That's
Painful. And then some people were.
Yeah, I can promise you we're going to get to.
I was just asking you, John. I mean, I was just saying, how many?
You, James Marsden.
Thanks to everybody. And Anthony, that was.
skipping ahead. Oh,
The basis for
John, that
oh,
that I wasn't.
Of deliberations. So we'll charge the jury tomorrow.
After the argument or before?
No, are you all calling witnesses?
That's what we're trying to decide. There are some issues with witnesses. I can go. I'll be happy to come back and go on the record.
Sure.
I want to be able to show the court that I wasn't making up this idea that there were photos on the cell phone. I did hear it from someplace, and I want to show the court.
Oh, no.
I had a good faith basis for that.
No, I'm fine with
No,
it.
but I think the record, ultimately, there may be some lawyer grading our paper. I'm not predicting what will happen.
Okay.
Also, we have, and I'm provided to counsel, snippets that show
the basis for
John, that John Hunter questions of the witness about Mr. Horace were made in good faith. He had a basis for that. And that witness, at least at this point, is unavailable. He was supposed to meet with us last night. I promised the prosecutor I would send him a summary of what the witness said.
Okay.
We now learn that there is a recording of what he said. Unfortunately, the witness has advised that he has retained counsel and he will not be available. He's going to invoke his Fifth Amendment.
Oh, well, who's the counsel he retained?
Pardon?
Who's the counsel he retained?
It's a civil lawyer in Houston named capital D, little E, S I.
Well, have
Oh.
the attorney appear by Zoom, and let's find out what's going on.
Well,
Please make this happen. Please make this happen. Because if the witness they had to testify regarding what Mr. Saldivar, the victim, was up to, and that witness will be invoking his Fifth Amendment right. Oh, that could be a mistrial in itself.
we've been trying to contact him, but I can represent to the court as an officer of the court that I can't talk to him anymore, that I'm going to assume that I think I have a right to rely upon his representation. He's going to invoke his Fifth Amendment privilege, and therefore I don't think we're in a position to offer the witness any longer. And as a consequence, and by the way, I'm going to tender to the court his name,
Okay,
his contact information, the lawyer's name, and I'm giving this to counsel.
All right, so let's do this.
Can I go to the bathroom?
Yes, and we'll wait for your client to come out so we can have everything on the record.
And then we need to talk to him,
Okay.
obviously, about what he wants to do.
Okay.
There
All right,
may-
and I'll give you all a chance to talk to him.
Okay, because that will depend on how many witnesses we have, if any.
Okay.
I'll be right back.
And apparently he is in Houston. It's always unfortunate when defense has a witness and then boom, they still don't. Because had that been the prosecution, they would have subpoenaed if they believed that that witness had anything interesting to say. And if they thought, oh, he's avoiding subpoena, they would have hauled his ass to court. But this is the defense. They don't have the power the prosecution has. Let's skip ahead.
We're trying.
This is the 9 judges.
Okay. And since they can't get a hold of that witness, it's a pause. Would anything happened? Now they are back there. Okay, let's see.
All right, so everyone, I just let the jurors know that we were running behind schedule and it wasn't due to any actions of the state or the defense. And I informed them that it had something to do with the building. And technically it does, because it has to do with transportation to the building. And so I let them know that throughout the courthouse, there's an issue with the building. I just didn't tell them it was transportation to the building. So the court is calling 2019 CR 12495 State versus Taymor McIntyre. Can I have parties announced for the record?
Jason Gearhead and Megan Galloway from State Farm.
John Hunter, Jerry Goldstein, Thomas Lang for Mr. McIntyre. He's present, Your Honor.
All right. So I believe there was something defense you wanted to put on the record.
Yes, Your Honor, but I believe we need to briefly confer with Mr. McIntyre, if that's okay.
Yes. So State, if you would just go in the back or either go in the back of the courtroom so that they can confer with their client.
Yes, Your Honor.
And to the media that's present, just make sure you're not recording their conversations.
All right.
Are making its way. That my metals are making its way through custom. For tomorrow, but they'll be here before Fiesta. No, thank you. Yeah.
Okay.
And she's been working on this case, RAC.
The record and defense, you stated there's something you would like to put on the record.
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. if I may good for my chief position.
Yes.
The court probably recalls the cross-examination, the able cross-examination by John Hunter of the state's witness, Joanna Reyes,
Mhm.
where he inquired of certain statements that she made, and the name Rashard, Rashard, Horace, Horac, to him, a boyfriend that she lived with for a period of time, I think a 1 month and a half in Houston, and was dating here in San Antonio. In that regard, the witness was supposed to arrive in San Antonio, told our investigator, Joanna Collins, who is in the courtroom, and she has been previously. She's a licensed investigator, and she's been working on this case with us for 4 or 5 years. And I would represent to the court as an officer of this court that the witness, Rashard Horace, who had promised or indicated to us that he would be in San Antonio, meet with her at my offices here in San Antonio at 4:30. Late last night, I believe it was after 7 p.m., he contacted Miss Collins, our investigator, and advised her that he had retained counsel and that he was not.
I really wanted her ex-boyfriend to come and testify, but apparently that's the guy who retained counsel and would plead the fifth. Ah, frick. That witness, I believe, was quite crucial for the defense because he could have told the jury all the lies of cocaine stripper.
Going to testify. He was going to invoke his Fifth Amendment privilege. Based upon that, we were confronted with several issues. One, I believe, under the Texas Code of Professional Ethics, rules of professional ethics, I believe it would be improper for us to continue to talk to him once he advised us that he had retained counsel. Secondly, it would be improper for us, I believe the law is clear, to call him as a witness to invoke his Fifth Amendment privilege in front of the jury. I know I would object to that at the state. Given those facts, we have been unable to reach his counsel, and I've provided the state with, and I would offer to the court what has been marked as Exhibit 12. I would advise the court that Exhibit 11, which has also been tendered to the state, and I believe one of the able counsel has listened to it. Ms. Collins advises that she didn't realize that when they called her office instead of her cell phone, that there was a recording. And so we have a recording of her conversation with him, which is important for purposes just of the record, not before the jury. But I would offer defendants Exhibit 11, which is the recording of the conversation between Joanna Collins, the licensed investigator, and Mr. Horace. And I have tendered it to counsel, and I would offer that solely for purposes of the record.
All right, so if you could label that so there's no confusion, D11R and D12R.
Problem here is that even though Texas is a one-party state where a recording can be acquired, as long as one knows about it and agrees with and says, yeah, I'm recording this and blah blah blah, yeah, whatever's. This deprives the prosecution from cross-examination if that witness will not testify and will only invoke Fifth Amendment right. I don't know if the judge can order or can allow this or not in Texas if there is no cross-examination, which deprives the defense from an actual witness. I would say it's that in itself should be a reason to declare a mistrial, because with the prosecution's knowledge, they have referred to this witness. Yeah, this is a hard one. Because I'm not familiar with how Texas law and statute handles this kind of thing.
I'll just add the letter R.
Defense.
Yeah, and then again, yeah, as Teresa Troy says, state got in statement without testimony and cross-examination. Yeah, with Wong, the crime scene investigator. They got those in, but they got it in through another witness. Now, can the defense call the investigator? Maybe. I don't know. It doesn't.
11R
Yes.
and defense exhibit 12R, which I've also tendered to counsel, is the name Richard Horace and his telephone number, which we are not calling because he's represented by counsel, and his attorney, which he advised us of, Donald D. Simone, D, small d, little e, capital S-I-O-M-I-M-O-N-E, with his telephone number. We attempted to reach the attorney last night. Did we call him again today?
No, I left a voicemail at both my cell phone and yours.
We have not heard back from them. But as an officer of the court, I don't think I can move forward when somebody is advised that they've got counsel and they're looking. As a consequence, we will not be offering the witness, but we wanted the record to adequately reflect what I think shows good faith. First, I have what's been marked as Defendant's Exhibit 13R, which is an excerpt which I provided to counsel sometime earlier today, I think, maybe an hour. And I had made a statement to the court with respect to the alleged child pornography. And I said it was on a cell phone, and I was corrected. I knew I saw it someplace. It is in the recording, and I would tender and ask that it be admitted for the record purposes only, 13R, Your Honor, in which the witness, potential witness, Mr. Horace, tells our investigator
And
that-
counsel, with regards to that, because the court is aware that there are certain connotations with regards to any offense of that nature. If you just want to admit it into the record, it's in the record.
just, I wanted the court to know that I was making a good faith.
No, I appreciate that.
About what I thought.
All right.
The statement on 2 counts. One, when I said that I was in error when I said it, now I withdraw that. I want to show the court why I said it. Secondly, Your Honor, I would offer defendant's exhibit number 14R. And it is, Your Honor, it is the excerpt that show the basis for the specific questions that Mr. Hunter asked of the witness, Joanna Reyes, the state witness, and it's being offered for the purposes of demonstrating that he had a good faith basis for asking those questions. We anticipating that we would have the witness, which we do not. We're not asking this to be presented to the jury, but I think it is important that the court knew that we didn't make that about the whole law.
Okay, so I will tell both parties in looking at 13R. So they are saying that some pictures were found inside a camera. Were there pictures found inside of a camera?
No. In fact, the camera was never recovered.
Well, by the way,
So-
it says cell phone,
All right, so,
and that's what I said.
all right, so with regards to defense 13R, nothing was ever taken from the cell phone. So it appears that if somebody was saying that there was something in a cell phone, I don't know if that was interrogation techniques or what, but do both parties agree that there was nothing, no photos pulled from the
We have
complainant?
no idea. It was never done.
No, there's no evidence of that, Your Honor.
Yeah, and of course the prosecution has had no interest in getting stuff off a cell phone. That may or may not have been illicit pictures of minors, which tanks the defense case in chief completely. Because another case where, because of the absolute, not absolute, but because of the state, their inability or incompetence of the investigator, the defense can't put up a proper defense because there is no evidence other than testimony from a person who will now no longer testify.
There is no evidence because nobody was able to look. Now, it's offered not for the purpose of the truth of the matter, but to show why able counsel asked those questions, because we expected that witness to say that that's what she said, which was contrary to her testimony.
Well, and if
Yes.
I can respond to that, because I've listened to the recording, and what is alleged is that the state told the witness that illicit material was found, which is fully untrue.
But
So
we're
that's
not
not really.
we're not offering it for the truth.
All right.
We're just offering to show the good faith basis for the question.
Okay, so this is, we're gonna have one person at a time.
I'm sorry, Your
I'm listening to everything. So, I have some questions and then we can talk about defense's exhibits. Are there any other exhibits, defense?
Yes, Your Honor, there is, I believe it's 14R, which is the basis for Mr. Hunter's questions. If you're still speaking about the photographs on the cell phone, which is, I think, what counsel was alluding to.
Okay, so, the only evidence that you are offering in for the record is 12R, 13R, 14R, and what is the?
11R.
And 11R, is that correct?
11R is the total recording, Your Honor,
Oh.
which has been provided to the state.
All right, so anything else that's being offered into evidence for the record?
Yes, Your Honor. The basis for Mr. Hunter's questions,
No, I mean, do you have any other exhibits to be offered into the record?
no.
All right, so, and counsel, you can remain seated. It makes it easy for the court reporter to hear. So I want to take these matters one at a time. All right, with regard to this witness, Mr. Horace, was he subpoenaed?
No, Your Honor, we didn't learn about him until he called Mr. Hunter night before last, emailed him, and Mr. Hunter appropriately said, I can't speak to you. I'd like you to speak to our investigator. And that's when the conversation the next day happened between Miss Joanna Collins and the witness.
All right, and I'm assuming that the email contained information that you thought would be relevant to this case.
No, the email that we're talking about, that he said, I've retained counsel.
Your Honor, just to clarify,
Yes.
the email contained a photograph of Mr. Horace with Ms. Reyes, which was tendered to the witness as defendants 10.
Mhm.
And we asked the witness to identify the individuals depicted in the photograph, and I believe the witness testified that that was her ex-boyfriend and her. And he indicated that he had information about the case, and that's why we directed him to our
All
investigation.
right, and so what date was this? That
Day
he,
before yesterday.
so we're saying this was Tuesday?
The initial contact was made on the 8th.
Okay,
And understand that we're not offering this to put it into evidence. We're offering it to show the good faith nature of his question.
so, all right, so I understand that. So then you all had no intention of calling him as a witness?
We did.
Well, we would love to, but he has advised us that he's invoking his Fifth
So,
Amendment privilege.
well,
And
this
what
is,
I'm advising the court is that we're going to honor that. And since we can't contact him directly, unless the court wants to continue this case and
no,
not,
let's call the attorney. It appears,
we've been trying, Your Honor, if the court wants to try.
all right, just give me a moment.
Sure.
And I'm assuming it's this law office that handles civil.
Another thing, this is why I really, really like Judge Boyd. Now, in this case, she has made a few rulings I do not agree with. Nothing unusual. But she could easily have said, yeah, we're done with that. But she actually makes the effort here to call counsel of the witness that should have been there. Let's see if they come back.
That will give us some warrants.
now Judge Boyd is back.
So what I have done, and there was no objections from the state or the defense, I've informed the jurors that we will start at 2. That will give us some more time to make sure everyone has what they need. So the court has in evidence for the record, Defense Exhibit 11 for the R, Defense Exhibit 12R, Defense Exhibit 13R, and Defense Exhibit 14R. And both the state and the defense went to chambers with the court. Neither party had an objection to the court reaching out to the attorney. Is that correct, both sides?
Correct, Your Honor.
All right. The court did leave a message. My understanding, that attorney is in depositions. Their depositions started at 10. They anticipate the depositions will be over with by 11. And one thing I can say about the civil side, when they do time announcements, their time announcements are exactly their time announcements. If they say it's going to be an hour, it's an hour. It's not more. So with regards to the defense exhibits, I don't know if y'all want to wait and come back at 1:30. I'm telling the jury to be back at 2. So at 1:30, we can see what the results of are with the attorney and with your potential witness.
That's fine, Your Honor, and we'll be at, I'm not gonna go anywhere, so I will be here in case they call back. We can do what the court suggested. I'll have my counsel. I would like to advise the court that when all this is over, so you have some idea where we're going. All we're offering it is to show that we made, that it was a good faith, those were good faith questions. I don't think that's gonna be an issue. The second thing is whether the state has the opportunity. This just relates to the question, other than the one with respect to the photos, to the questions that Mr. Hunter asked. I am asking the court to consider when this is all over with, if we don't have a witness, that the state not be allowed to argue or infer that we were somehow dilatory or not being honest in asking those questions and not having a good faith basis for them. If that's the case, I believe I'm being made a witness in this case, and I'm going to have to move to withdraw. Your Honor.
All right. So what I can say is with regards to Defense Exhibit 13R, it appears that this is some sort of hearsay within hearsay, because it's saying that it's alleged that the witness is saying that a district attorney and a private investigator told her something. And it's not a statement that, it doesn't appear that it's a statement that she made.
No, that's with regard only to the photos, and that's not the issue. The issue is with respect to the questions that Mr. Hunter asked. The photos didn't come in, and the court admonished the jury at length, and as opposed to our instructions, she admonished them at length not to consider it. I just wanted to show that I had a reason to believe that I said it was on the phone. What we're talking about is the questions that Mr. Hunter asked, and we used his name because we thought he would be here, and I believe we're entitled to, since the witness denied it, and we don't have a witness to rebut it. All we were offering the statements for is her statements that are exactly contrary and mutually exclusive with what she testified on cross. And if all I'm saying is Mr. Hunter had a good faith reason to ask those questions, and we shouldn't be put in a position of, if we're doing it in good faith, making it look like we didn't make any efforts to produce the witness. We're availing ourselves of the able court's process. If we can get him, great, but otherwise I don't think we should be made to look like we didn't offer. There were witnesses that they said are out of the country they can't get, who were material. She was the head and senior CSI officer. Can we argue that they are responsible for her not appearing? I'm just saying that
I think legally you can argue that she didn't appear.
Okay, I understand that. I'm concerned that
Your Honor,
that it's going to look like us, and it deals with our credibility, that we misrepresented the fact that he said that. And since they're not going to be able to see that he did say that to us, I wanted to be sure the court knew we had a good faith reason for it. And I don't think that we should be punished for that. I think we followed the ethical rules, and I think it puts my credibility and Mr. Hunter's credibility and ethical consideration. We got the wife of a very well-known lawyer in this town on that jury. I don't want my credibility or my ethics to be put in, and I think they've created a problem.
They have a lawyer in the jury? Wow.
For me, all I'm saying is, as long as they don't say that, look, they asked those questions about this guy and he didn't show up. He's entitled, if he's gonna invoke his Fifth Amendment privilege, let's have him invoke it before the jury.
And Your Honor, just very briefly, if I can add a little addendum to what Mr. Goldstein says, and this can be discussed more at the charge conference. What I think Mr. Goldstein is urging is that there would be limitations on what the prosecutor would be entitled to argue based upon that portion of Ms. Reyes's testimony, in the sense, but that there is a curative instruction that would be perfectly reasonable, that would apply to both sides that can be given, which is to simply instruct the jury on the function and the purpose of Rule 613 in the charge, and to explain. You have heard statements in the course of this trial that are attributed to witnesses, some of which were adopted and agreed upon, and some of which were denied. You are to understand that any such statement is not being offered for its truth, but merely to confront the witness about whether or not they said it. And it is to be considered by you only in determining whether or not you find the witness credible.
I'm not putting that in a jury charge. Here's the thing. You all question witnesses. You all make your objections. I make a ruling on those objections. The jury, I don't believe, is thinking, oh my gosh, is the defense or is the state saying something that is untrue? The only thing they know is an objection was made and the court ruled on the objection. Either I sustained it or either I overruled it. I don't see how 613 comes to play in the jury charge. And I think we're moving far afield of defense's exhibit state.
I believe we're entitled, and I would re-urge now, and I will, if the witness testifies, we don't have to worry about it.
All right, let's cross that bridge when we get to it. Because
I'm happy to wait. I just want to give the court notice, and I want counsel to know that if the witness is not going to testify, that we made our reasonable efforts and fulfilled our ethical obligations to our client. And I believe that puts my credibility in issue and John Hunter's credibility. And I'm going to move to withdraw. I'm not going to have that jury have the idea that somehow I'm engaged in chicanery.
It would be, what we're discussing, Your Honor, would be the issue of, while the prosecutor is well within their right to say that those statements were offered.
Okay, here's the thing. You all are talking about a jury charge. We're not at a jury charge state yet. The only thing we're at right now is, do you have any witnesses? It appears that you wanted a witness here. That witness is stating that they've retained an attorney. You all have tried to reach the attorney. You all have agreed that the court could reach out to the attorney. I'm telling you, the attorney is in depositions, started at 10 a.m. I'm being told that those depositions should probably last for close to an hour. I left them my cell number. They're going to zoom in. When they can zoom in, you all will have a chance to speak with them. But so both parties are aware, and this was an assistant. I'm assuming it's the assistant to the attorney, which it's hearsay, double hearsay. But she says they do not represent him in anything other than a civil matter.
Oh,
it has to do with an accident.
Have a conversation with Mr. Horace.
Yeah. So that's all we're doing. We're not arguing the jury charge, what comes in, what stays out.
And the real question is whether he's doing it on advice. If it's not on advice of counsel, then I'm entitled to talk to him.
Well, we're going to find out.
And more importantly, Your Honor, regardless of that, I want to talk to him. But if he invokes his Fifth Amendment privilege, that ends my ability to deal with him unless the court wants to challenge whether he has that right. I'm happy if the court instructs me to, if he calls back and he invokes his Fifth Amendment privilege, to have him testify before the jury, question by question.
Yeah, what will end up happening, if you think he's going to invoke his Fifth Amendment rights on every question, then we can have a hearing outside the presence of the jury and see if that's the case. So other than this witness, maybe, are there any other witnesses?
It would depend on whether that witness testifies, but I can assure the court it would be short and that we're not going to have more than an hour and a half, maximum 2 hours of testimony, or at the max.
All right. Then state your response.
Regarding defense exhibits 11 through 14R, I take issue with the fact, good faith argument, okay, because the question that was asked by Mr. Hunter to the witness, Joanna Reyes, was, did you tell Mr. Horace that you personally observed child pornography on the camera?
But that's not the one that we're
no. So, all right. So both parties. I will allow both sides to put what they want to put in the record. So once the state's finished, then defense, if you have some response, you can respond. State, once the defense responds, if you have some response, then you can respond. So state.
The witness denied that because the witness never told that to Mr. Horace. And
well,
he in fact did. Let me finish. In the recording that was provided to me by defense counsel, Mr. Horace explicitly states that Ms. Reyes told him that the state told her that they looked in the phone and there was some examination on a cell phone and that there was child pornography. That is absolutely not true. The phone was never examined, and there is no evidence at all of the child pornography. And so at the time, it's untimely now, but it was improper impeachment by Mr. Hunter that I couldn't object to because I was just provided this recording this morning. And so that's what I would like the record to reflect.
And if I may respond to that, Your Honor, since that issue is directly pertaining to my question. As Mr. Goldstein explained, we did not have the benefit of the recording when the questioning was done. I had the benefit only of rough notes from the investigator. Secondly, I think that the prosecutor's argument misapprehends the basis of Rule 613, and we've made that record as explicit as we can. And I understand that there's disagreement, but we stand on our papers.
Then it's not offered for the truth, Your Honor. It simply was offered to show a prior inconsistent statement, and that all I'm interested in.
Well, no, because from what I'm reading
Yes.
is that according to the video that you all have given the state access to,
It's
and
an
that's
audio,
been,
Your Honor.
and that's audio.
It's an audio.
All right, the audio and that what's been admitted for purposes of the record, I guess it's D11R.
It's the 11R.
All right, so in it, according to what's been transcribed, the witness never said that she saw the illicit material. She's saying that a district attorney and a private investigator pulled her in a room and said, "This is what we saw."
Which we didn't have the recording
No,
at the time that so.
and I understand that. And what I'm telling you both is I am not saying that either party has done something untoward. I'm not saying
The state
that.
has. I mean, that's the implication of what
No,
the
what
counsel
she's-
is saying, is that we have done something.
All right, so here's the thing. All of you all are attorneys. I don't think anyone is going to do a closing arguments and say these attorneys are unethical. It's not allowed. State, do you have any intention in your closing argument, and I don't want to go into great detail, of saying that these attorneys are unethical?
It's not allowed, but it's evidence, Your Honor, so I am satisfied.
So that would be a no. So I don't understand why we keep going about being unethical and whether or not a jury thinks we're unethical, because you all make objections, both sides. I make my rulings on those objections. The end.
Well, no, if an argument's going to be made that we failed to call the witness, then we're going to ask to reopen. And if we're not allowed to, I think it does imply that we did something in terms of not calling the witness. And if the witness insists on their Fifth Amendment privilege, I think that puts us in a bind, an ethical bind. And I'm simply not going to have this jury believe that I did something like that.
You're not the person who even asked the question. Your co-counsel. Is your co-counsel going to withdraw because the jury will think that he did something unethical? Because your co-counsel is the one who was cross-examining the witness about, what the witness may have said. So if someone is saying that they're going to fall on their sword and withdraw, then it wouldn't be you. You didn't ask the question.
Oh,
Yeah,
just like the prosecutors.
Hold on. There are two issues at play. The first is that the implication of what able counsel for the state just remarked about is, I think, plainly an indication to the court of a plan to strike at the defendants over the shoulders of counsel. And secondly, the way in which this process is going forward is attempting to drive a wedge of conflict between the defendant and his counsel, which is an issue under Strickland versus Washington. And it is a problem that has deeper implications.
All right, so let me give you all the deepest implications in this case. You all ask questions. People make objections. I rule on those objections. And you all can accept my rulings or not. But what I am telling you is, one, I expect everybody to follow the rules of evidence. I expect everybody to follow the rules of professional conduct. And if you don't follow the rules of professional conduct or the rules of evidence, that's where I step in. Now, if somebody believes that there's a wedge between them and their client, then file a motion. We are not here at this juncture to talk about the charge and what will be in the charge and the arguments that people can and cannot make. If you all want something specifically, and this goes for the state or the defense, that somebody is not allowed to argue, then file a motion. That's what I can tell you. That's the way it should be done.
We will do so. Thank you.
Now, other than this witness who may or may not appear and may or may not be available, are there any other witnesses?
There is before the court, and I believe it's been marked as 14, Your Honor.
14R?
14R, D14R.
Yes.
It is that clip from an Instagram from a Miranda Hubbard. I will tell you that it was at it's YouTube, Your Honor. And I'm not sure with this game. Can you tell that from this? Anyway, it is before the court. Counsel has a copy of it.
I don't have a copy of it. What is
Well,
it?
it's in that, I put it out for,
Except not yet. Which
it
one?
is marked.
It's marked, but you haven't given it to the judge.
I believe we have. Yeah, can we?
No, I
all right.
have
14R.
12,
It is
13, and
14 R,
15.
Your Honor.
That was it.
That would be 15R.
No,
You gave it.
let me see, may I see 14 R, Your Honor?
Sure.
Right, then this is 15 R, thank you.
And I'm sorry, let's go off the record for a moment.
Thanks for calling. Keep the phone locked.
Oh, now the attorney's calling back. Or skipping. Oh, this is nerve-wracking. Well, at the end of this, we are actually caught up completely and minutes away from 1:30 p.m. Let's see it. Time in Texas right now. Yeah. So we are almost exactly caught up.
This defendant,
Okay.
On the record, with respect to defendant's exhibit 15 R,
all right, what is defendant's 15R?
that is the.
We're not done, State. Sorry.
Sorry,
I thought we were done, but
I
we're
know.
not. No problem.
He called when we were. This is the reply. Is this YouTube?
I believe it's YouTube, but
It
you saw
appears
it.
to be YouTube.
Let me see.
And this, the first page is a cumulative exhibit D15R is the comment that was on it. The second is the.
Okay, may I see that?
I just want the record to reflect what you're getting.
Okay.
And the last is a list of calls. The first five, Ms. Collins, who is listening, and she can correct me if I'm wrong. She called last night. The rest of them, she's either called and she went by residence because connected to this woman. as well.
Sure. No problem.
Thank you. Is this all about?
Who?
So none of those
Whose
are to
YouTube
admit
is it?
judge, right?
Is it mine? Oh God, I hope it's not my channel.
All right, so are you telling the court that this is the person you want to call as a witness?
If we can reach her, Your Honor, we're still trying.
You've seen it, Judge.
They got a copy of it.
All right. Is there anything else?
We're still trying to reach her, Your Honor. The court asked us, did we have any other witness? I wanted to show the court what we're trying to do because I got an email last night at, I think it was 11 o'clock, telling me hey, you ought to look at this thing because I don't read those comments.
All right, well, it says here that the witness is a cashier, so everybody knows where she's employed. Just go subpoena her.
Do we know, can I ask?
I mean, no, that's what it says on the exhibit that you gave me.
Well, that's what she said, not what I'm saying. Can I find out whether perhaps we've already explored that? May I ask the?
Sure, but what we're going to do is we're taking our recess now. You all need to be back here at 1:30.
Thank you, sir.
All right.
Yeah, and with that, we are now just waiting for the Judge Boyd to return. I have here, you see, her page. Oh,
Without,
Yeah.
I think we're gonna rest.
what?
Okay, so if you are going to rest,
Yes.
then if all of the jurors are here, I want to bring them out so I can send them home early.
Okay.
Yes,
And Your Honor, when we get back on the record, right before you do that, without,
So
I'm solving.
the one witness, so they wanted two witnesses. One got counsel and was invoked in the fifth, and the other one apparently they can't get a hold on. And yeah, that's an issue.
Several problems, but I'd like to just say, can we re-urge our right to invoke our client's Fifth Amendment privilege in front of the
I thought you were going to say, you know what? I would like to put on the record that Judge Boyd, you're one of the best judges that I've ever seen in my
Okay.
lifetime. I thought that's what you were going to say.
I will adopt that. I will adopt that, Judge, on the record. But then I'd like to say that I think we're entitled to represent that to the jury, so they're not in any question about it. But we can also deal with that at the charge. But I'd like to go to the bathroom, and then
Oh, yes.
we're gonna need to. And we got lots of time. I just realized.
Oh, what?
We're resting.
No, no,
Oh, then you can bring them in.
Yeah, I was going to bring them in and not let
If
them
they're
wait.
here, the more time, then we haven't been to sleep. You gotta understand that that's the problem with all these extra witnesses.
You guys haven't been to sleep?
I haven't. I'm 81 years old.
Oh.
By the way, that one thing I got at 11:30 last night, that defendant's exhibit 15R.
I was amazed how many attorneys I ran into at the jail at 11:30 at night.
Oh, well,
I saw
that
more
is-
at 11:30 than I do when I go at 2 or 3 o'clock.
Well,
And
that
Mosey, this was not easy to rest. Now, I'm gonna go rest my bladder.
Yes,
I'll be right
yes,
back.
okay. I will tell you that when I first started practicing, I would go to the jail late at night, and this is me riding the bus, and Cornelius and my investigator, Grantley Boxill, Grantley Arthur Charles Boxill, who's since passed, he would say, Stephanie, don't you ever go to the jail at night. I'm like, the jail surely would be the safest place. I mean, it's the jail. All people there, they're like, no. And so after that, the only time I would go at jail at night is if I was going with them. But Cornelius, that's his usually time, nighttime. And I said, oh my gosh, because he'll always send me photos and say, what's going on here? It's flooded. There's nobody here to answer me, so I can go and see my client. And then I sent emails to everybody. I sent emails to Commissioner's Court. And yeah.
Years and years ago, my wife and I went out to the jail to take photographs of those jailbird cartoon characters on the walls of the bail bond company with
Yes.
the neon lights and stuff. I thought it'd be kind of a noir kind of a photograph.
Mhm.
We were having some fun with it. And there are a lot of people who've been recently released from jail or who are just perennially homeless that hang out there.
Mhm.
And they're walking up and they want to bum a cigarette and they're trying to look at the camera equipment and I'm trying to keep them all at bay. And my wife's like, these are the people that you represent.
Yeah.
Yep, that's it.
Well, I will tell you, I always enjoyed my clients and hearing their stories and enjoying going to visit them at the jail. I would always go every week, and every single client I had at the jail, I would visit every last one of them, whether they had an upcoming court date or not, because sometimes I'm the only person who would visit them. And sometimes we would just talk about, how are you doing? I'll never forget my one client who said, hey, did you see the new Godzilla movie? So that tells you how long ago that was. And it was with, I think Matthew Broderick was in that. And I told him, yeah, I did it. And don't do that.
Step on all the plastic surgeries.
Yeah. This is when off the record when. Oh. Okay. When off the record. Oh. She started anew. When Judge Boyd is off the record. Sorry. The conversations you hear here are not unusual. What happened in the YSL trial where prosecutors and defense attorneys don't like each other, especially when the prosecutors are complete and utter asswipes. That's not the norm. This is what normally goes on. They talk to each other, they joke with each other, they tell stories to each other. This is what actually goes on. Thank you, Erica. Thank you, Rocco. Thank you, Gigi. So yeah, we are now waiting for everything to start, and it seems like the defense witnesses, one made itself unavailable because got themselves a counsel and claimed, yeah, I'm going to plead the fifth. The other one was from a YouTube comment on, I believe it has, I don't know which one, which also made itself unavailable, which makes that the defense doesn't have a case in chief. And probably the defense will rest. So, but which means we only have the state's case in chief to go after. In my opinion, we're
We've
nowhere
done that
near.
To accommodate our objections, we just maintain that that there's still problems with these recordings, even though they are redacted.
Okay.
So, I mean, I think that the record we had yesterday was pretty thorough about it, and it will be evident when I say that. And
And the way we left it, Your Honor, I think, is that the court had asked her to redact it. And we are no longer arguing is that they've rested. We're gonna say, let them do that with our objections, and the court doesn't need to rule again. We can rely on the court's ruling.
Okay.
Okay, then we're all good.
All right. All right. Do we have all the jurors here?
Yes, we can begin there.
Yes.
Are they in that room that's right back there?
Yes, they're down the hallway in
When
that
I
jury.
go to the restroom, I do want to tell the court, I walked to the restroom during the lunch break, and the door was open, and I'm sure they saw me. I didn't look in, but it dawned on me when I walked by that they were in there, and then I walked back by, but I didn't.
Okay. Oh, that's no problem.
Well,
And they already know that nobody's going to speak to them, so.
and when you're standing outside waiting for somebody to give you a ride, I try and stand as far away from them as I can,
Mhm.
but
It happens.
it's not that big a place.
Yeah, as I said.
All right, we're going to go on the record in 2019 CR 12495, State versus.
And we are
Taymor
actually
McIntyre. Can I have
live now,
parties
folks.
announced?
We are
Megan
live.
Galloway and Jason Garahan for the state of Texas.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor, he's present.
All right, are both parties ready to proceed?
The state's ready, Your Honor.
We're ready to proceed.
Based on the state's case in chief, all they have is the word of cocaine stripper. That's it. That's the only thing that actually puts the defendant on the scene with the gun and firing the gun. And she got a plea deal. So after this trial is done, she has a 1.5 year probation, and she can ask to get her record expunged, and then she walks free, scot-free. And I believe that she set everything up. That she just pointed the finger at Tay-K to get heat off herself. That is my opinion. You can agree or disagree with me as long as it is constructive. But I believe that when the only thing you have to point the finger at the defendant is a prison snitch, it should never have been brought to trial. Never. I don't like snitches at all. At all. Especially from the prosecution.
All right, for the jury.
Everyone, please be seated. And I believe there was a discussion and there was no objection. State you wanted to briefly reopen for 2 exhibits.
Yes, Your Honor. And at this time, the state offers states 118 evidence.
Okay, and I'm sorry, 1 exhibit.
1, yes, Your Honor.
And that states exhibit 118.
Correct, Your Honor.
All right, defense.
Your Honor, we renew our objections from yesterday in full. We also take exception and object to the court's ruling.
All right, the objection is overruled. States exhibit 118 is admitted. All
We
right,
rest, Your Honor.
and defense?
The defense rests, Your Honor.
State, do you close?
Yes, Your Honor.
And defense, do you close?
Yes, Your Honor.
All right, thank you. So, ladies and gentlemen, you've heard all of the evidence in this phase of the trial that you're going to hear. What is going to happen is I'm going to have you all come back on Friday at 9 a.m. And at that time, I'll read to you what's called the charge of the court, which is the jury charge. And both the state and the defense will have a chance to present to you their closing arguments. You have not been given this case to begin your deliberations, so you are not to think about it, talk about it amongst yourself, deliberate with yourself, or discuss this case with anyone, or do any type of investigation. If you see anything about this case, you're to ignore it. Does everyone understand? All right, so we can go off the record. And I know sometimes people may need medication. So if there's some medication that you may need, and when I say medication, I mean, sometimes people forget to bring their blood pressure medication for the day or something of that nature. So if you have that, please make sure that you bring it tomorrow, because once you all begin your deliberations in the jury room, no one is allowed to speak with you. Everything that, any questions, I should say, that you may have, or any any questions that you may have, or any communications, that will have to be done in writing. So if there's some type of medications similar to that, because we're going to be starting early in the morning at 9, just make sure you bring those. And if there's some medications that you have that you need to eat with food or have on an empty stomach, just let us know. Any questions before I excuse you? All right, so enjoy the rest of your day. It's turning out to be a little bit hot outside, but I think it's still beautiful. All right, everyone, please rise for the jurors.
Yeah, this with no defense case in chief is not on fault of their own, but even without a defense case in chief, I'm nowhere near beyond a reasonable doubt. Because, as I said earlier,
everyone, please be
all the
seated.
state has is a
So this is what we'll
is a cocaine pothead stripper's word that she said when she got a deal, because she was seeking a deal to get out of capital murder herself. That's the entirety of the state's case. That puts Mr. McIntyre at the scene with a gun shooting. That's not enough. For me, at least.
If both parties can confer with the court reporter to make sure that every item that was admitted, that the records are in order and it's clear. And then after you all do that, what I'm going to do is we're going to go over the jury charge, and I'll hear what you all think you want in the charge. All right? So if y'all could do that with the court reporter.
Yes, Judge.
Thank you.
And Your Honor, I believe I left defendant's exhibit 15R on the court reporter's desk. I mistakenly took that with me. I think that was the only time.
Okay. All right.
That's that.
Give it back.
Huh?
Yeah, you give it back.
Yes.
Okay. That seems to be what I have for you. I was so looking forward to the defense witnesses, or the one defense witness, the ex of cocaine pothead stripper woman. who made himself unavailable for the defense. So I was so looking forward to it, but even without the defense case, even without a defense case in chief, for me this isn't. No, I can't reach guilty beyond reasonable doubt on the words of a pothead cocaine stripper.
It didn't go back. It did go back. Yeah, it doesn't go back. It's marked, so. Judge?
I think we withdrew it.
Yes.
Okay, now they are just talking about evidence in or out that they might have forgotten. Yeah. I can't in a good conscience say I'm anywhere near. Not on the words of pothead cocaine stripper woman's testimony, which she only gives because she wants to save herself from life in prison. I can't. There is simply no way. If you're of a different opinion, yeah, but that is my opinion. I'm not entirely sure when they start tomorrow. I think they said 9:30 with Texas time. So I guess I will see you here tomorrow, 9:30. I expect closing arguments. Well, jury instructions, or in what they call in Texas, jury charges. And then closing arguments. And then we are at verdict watch. So, folks, after 4 hours today, with a lot of information, a lot of information, we will see each other tomorrow. Bring friends. Hit the like button, subscribe if you haven't. If you think you are subscribed, check again. YouTube loves unsubscribing people. But I will see you tomorrow. Have a good one, and remember, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.
Sail the raven waves, brothers.